be called for, or the matter may be taken up after completion of motion or Act 2, my lord, anytime, either in completion or in Act 2, my lord.
Call for. Affidavit call for.
Wait, please, Lordship. Item number 38 may kindly be adjourned. The LCR is not received.
Item number
38
LCR not received.
not received.
As spread for by Mr. M. Rama, learned counsel for the accused, resolution the matter after 1 week.
After 1 week.
In the meantime, resolution issue reminder to the learned trial court for transmitting the scanned copy of the record.
Obliged.
Lordship, in Action 36, Lordship, we have filed affidavit on behalf of the respondent yesterday. That may be called for, Lordship.
Okay.
May it be the Lordship. May it be
Yes.
the Lordship. Also, I'm praying for listing of a matter on 19th, Your Lordship.
When?
19th, Wednesday, Your Lordship.
Well, with regard to item 37, Madam, I'm being led by Senior Counsel D. Das, and he had to leave the court by 1:30. He has a flight to catch at 1:30. So may I make a prayer that matter can be taken up at 11, because I have to inform the other side also at 11 o'clock, because this is a transfer matter and it's been pending since last 3-4 days, Madam.
No, that's all right. It is pending because of you people, not for the fault of the court.
No, my lord, we're giving our best, my lord. But today, my lord, the situation is such, my lord. The senior counsel, he has to catch a flight at 1:30, my lord. So he have to leave the court by 12
No,
o'clock.
some other matters are equally important matters. are also there.
I understand, my lord. I
Then
understand. I am
How can
making,
you
I'm
raise
making
that your matters
my
will be
lord,
taken up at 11 o'clock?
if my lord allows, my lord.
Okay, okay, we'll try.
But I'm deeply obliged, man. Deeply
Lordship, with the consent of the other side, I beg to mention item number 22. The matter may be passed over for the day.
Your good name, please.
R.K. Sharma for T.
Mr.
Chakraborty.
R.K. Sharma, learned counsel for the
T. Chakraborty.
learned
Representing
counsel appearing on behalf of Mr. P. Chakraborty. Learned counsel for the petitioner. Resolution is the matter. When
as per your
matter
convenience,
stands
Lordship.
adjourned for the day. Yes.
Obliged.
May please, Your Lordship. I beg to mention for listing of 2 matters, my lord. There is urgency next week, any date, my lord, as Your Lordship, as follows.
Take it from.
My lord, I beg to mention item number 11, my lord, motion matter, my lord. My lord, this matter may be adjourned for the day, my lord. After 10 days, my lord, we need some further instruction, my lord.
On the prayer being made by Mr. S. Rana, learned counsel for the petitioner, resolution is the matter after 10 days.
Lordship.
Obliged.
May please, Lordship. I beg to mention for listing for withdrawal, Lordship. For withdrawal, Lordship. Tomorrow, Lordship.
May it please your lordship. Lordship, I pray for pending writ petition, lordship. Matter is admission column, lordship.
When?
Next week, any date.
Take a date from it.
May it please, my lord. Prayer for listing of 2 writ petitions, my lord, as per Lordship's convenience next week.
Take a date from him.
Deeply offended.
Yes.
May I please, your lordship? Lordship, I beg to mention item number 49 and 50 for adjournment.
Why?
Lordship, MS Dibogwa out of station for her medical treatment.
Okay.
49.
On the prayer being made by Miss, your good name, please.
Ambora.
Learned counsel appearing on behalf of Miss P. Orgumai. Learned conducting counsel for the petitioner, resolution is the matter after
3 weeks.
3 weeks. There.
Obliged, lordship.
My lord, this matter may be listed for admission on next Monday, my lord, 17th.
Monday.
May I pray, madam? This is a contempt petition for violation of the honorable court's order
The judgment is page 15. Relevant portion, page 20. Paragraph 14. I was placed under suspension. Thereafter, was withdrawn. And there was a speaking order. The departmental proceeding could not be proved against me. Therefore, the departmental proceeding was dropped. But in the speaking order, there was no mention what would happen to my period of suspension. They did not regularize. Therefore, I approached the Honorable Court. So this Honorable Court, the paragraph 14, has directed to submit a fresh representation and before the DHE and the college. And it was directed that the college would furnish a copy to the director, a report to the director, on the basis of which the decision would be taken to regularize my period of suspension within 4 months. That 4 months have expired.
When it expires?
My lord, the order was communicated on 8/10.
Thereafter,
On 8/2/2025, it has expired. Page 22 is my representation.
heard Mr. A. Bhattacharya, learned counsel for the petitioner. This petition under Article 215 of the Constitution of India, as well as Section 12 of the Contempt of Court Act, read with Rule 9 of the Contempt of Court, which indicate Guwahati High Court Rules 1977, is preferred by the petitioner. Sri Manav Dekka for willful disobedience of the judgment and order dated 1/10/2024 passed by this court in WBC number 5104 of 2024. The learned counsel for the petitioner submits that by order dated 1/10/2024, the respondent authorities were directed to dispose of the representation filed by the present petitioner within a period of 3 months.
4 months.
4 months from the date of communication of the order.
Yes.
But despite communication of the order of this court dated 1/10/2024 on 8/10/2024, the period of 4 months elapsed on 8/2/2025. Until that, no action has been initiated. Now, till that, the representation remain on disposal. Yet to be disposed of. The submission of Mr. Bhattacharya needs further consideration. That the sisters notice be issued to the respondents by registered post with AD and also by usual process within our computer. Less than matter after 4 weeks.
Can a date be fixed, madam? Can a date be fixed, madam? Obliged.
May I please? My lord, the operative part of the order, lordship will find at page 29, paragraph 7, my lord. Here, my lord, the present petitioner has been selected for the post of grade 4, but the my lord, somebody, my lord, who has not been selected has filed a complaint before the joint director, and there was an inquiry, and inquiry was, my lord, pending before the concerned authority. Now, para 7, lordship will find the direction part.
Heard Mr. Mandal, learned counsel for the petitioner. This petition under section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, is preferred by petitioner, namely Mohidul Islam for willful disobedience and deliberate violation of the order dated 12/11/2024, passed in WPC number 844 of 2019. 2019. Mr. Mandal submits that the order dated 12/11/2024, specific direction was issued to the respondent authorities for consideration of the inquiry report dated 21st of October 2019. Within a period of 2 months from the date of receipt of the certified copy of the order of this court. And the said order was communicated to the Director of Education BPC on which date?
1911, page 30, Lordship will find.
On 19
11,
2024, but still that no action has been initiated by the respondent. Contempt. Let notice be issued to the respondent, returnable in 4 weeks, step be taken by registered post week, again also by usual process, within a week not today. List after 4 weeks.
Deep doubtless. May I please? Please 14, paragraph 14 is the operative part. Non-supply of the copy of the inquiry report was the issue, my lord. And there was a direction that within 30 days, inquiry report to be communicated to the petitioner, my lord.
When you have communicated the order?
It was communicated on 5th of June. And I submitted my reply within the time frame, my lord. They fixed 20th June 2024. As on date, nothing. Judgment dated 9/2/2024.
When you have communicated the order of this court?
1/3. Next day, madam. Next day, the copy I received on 28/2/2024. Copy of the judgment, my lord. On the next day, my lord, I submitted page 16. Violated twice, my lord. They have to communicate me within 30 days. They communicated me on 8th. And thereafter nothing, my lord. As on date, no logical conclusion to the proceeding.
Or Mr. Your good name, please?
S. Sharma.
S. Sharma, learned counsel for the petition. This petition under section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, is preferred by the petitioner, namely Dinesh Koleta, for willful and deliberate violation of the judgment and order dated 9/2/2024, passed by this court in WPC number 6581 of 2005. Mr. Sharma, learned counsel for the petitioner, referring to order of this court dated 9/2/2024, has stated out that So what is that, what was the time frame?
Time frame was 30 days to give me the copy, inquiry report, 15 days to findings, and 15 days to conclude the proceeding. Paragraph 14, page 14. "30 days for supply of the copy of the inquiry report, 15 days to the petitioner for his reply, and further 15 days at page 15
Mr.
to pass
Sharma
necessary order."
submitted, in the, referring to the order of this court at 9 to 24, especially paragraph number 14. Mr. Sharma submits that this court, while relegating the matter to the Director of Secondary Education, struck the present contempt of, directed him to serve the inquiry report, copy of the inquiry report to the petitioner within 30 days from the date of receipt of the copy of the order. Then further directed that upon such receipt, the petitioner may present before the director against the finding arrived at by the inquiry officer within a further 15 days time. And further directed that the director will pass necessary order within 15 days therefrom. And the order was communicated to the director on 1/3/2024. But no action has been initiated so far. You have not been furnished with the copy inquiry report.
They supplied me, madam. Page 17. Supplied me belatedly, madam. 5th of June, page 17, my lord.
Then further, Mr. Sharma submits that thereafter, belatedly, the director has furnished a copy of the inquiry report to the present petitioner. And thereafter,
I filed my reply, my lord. Page 18.
then thereafter, the petitioner has filed his reply on 28/6/2024. Then
Thereafter, nothing, man. They have to finish it, madam, within 15 days. They have not done it.
thereafter, no action was taken. Upon the reply furnished by the present petitioner. Though the period of 15 days already elapsed. Be that as it may, let notice be issued to the respondent contempt by registered post with AD and also by usual process, we can come to place the matter for it after for
Item 5. May I please, Lordship? My lord, before starting, my lord, I like to apprise the last order, my lord. Today is the date fixed for consideration of the some interim order, my lord. It was fixed today, my lord.
Lordship, we are directed to produce some instruction, Lordship. I have received the instruction, Lordship, but this is not sufficient. So, Madam, first of all, time being, I will get the updated instruction. I was directed to produce, Lordship, instruction. I got the instruction, but this is not sufficient, Lordship. So, the department is providing me the additional instructions after some time, Lordship.
after some time.
After some time, Lordship.
Okay, after some time.
At 2,
Let
my
us-
lord, at 2, my lord, because I'll be preoccupied in another court.
All
Or
right.
before that, if I come, my lord, then it's all right.
At 2.
At 2.
Lordship.
I got to sign over. You, I,
May I please, Your Lordship. Lordship, this is regarding non-provincialization of the services of the petitioners, Lordship. Both the petitioners, Lordship, they are working, Lordship, in Dhubri Senior Secondary School, Lordship. And their names were forwarded for provincialization by the principal. Lordship, may kindly come to page number 44. Otherwise, Lordship, as because there is no interim prayer, Lordship, at this stage, notice of motion may go, Lordship. And Lordship, admittedly, Lordship, one inquiry was conducted and subsequently the Inspector of School Dhubri submitted a report saying that, Lordship, the petitioners are eligible for provincialization and their cases may be considered. Though the report was submitted in the year 2022, but nothing is happening thereafter.
Presentation.
Yes, please. Page number 44, my lord. Page number 44, Lordship, got it.
An order has already been passed, Your Lordship. Page 48, Annexure 7. Dated 4/2/2021.
This is Lordship, this is the provincialization order of the school, not that order, Lordship. This is the provincialization of the school. School was provincialized. The name of the petitioners were not there. And Lordship may kindly come to page number 44 first. Serial number 2, Lordship. My lord, got it. Page number 44. Number 1, Sanwar Hussain, that is the principal. Number 2, Sheikh Muhammad Ali, that is petitioner number 1. His name was there. And number 4, Akhtar Hussain, that is petitioner number 2. The name of the petitioner number 1 was for senior assistant. Name of the petitioner number 2, Akhtar Hussain, his name was forwarded for library assistant. Now, Lordship, kindly come to page number 48. The order just now my learned friend has referred to. This is the provincialization order, Lordship. My lord, may kindly come to page number 49. Serial number 9, 10, 11, 12. 4 persons. The services of these 4 persons were provincialized under the category of non-teaching staff. Though Lordship, name of 6 persons were forwarded by the principal, and 2 persons, the petitioner number 1 and 2, their name were not considered. Now, Lordship, may kindly come to page number 50. Yes. Page number 50. This is the representation submitted by the principal. And thereafter, Lordship, on the basis of this, page number 52 may be seen, Lordship. Page number 52. With reference to the subject cited, this is by the Inspector of Schools. With reference to the subject cited above, I have the honor to forward herewith the prayer petitions received from so-and-so, in connection with the post of provincialization under Provincialization Act 2017 and 18, after proper verification and justification thereof. Now, Lordship may kindly come to the next page. Page number 53, serial number 90. Sheikh Nur Muhammad, Dhubri Girls Junior College. Prayer is justified and recommended. Lordship may kindly come to the next page. 54, serial number 98. Akhtar Hussain, Dhubri Girls Junior College, library assistant, recommended and justified. But thereafter, Lordship, nothing is happening. Lordship may kindly issue notice at this stage.
Third, Mr. A. Ahmed, learned counsel for the petitioner, and Peters, learned additional learned standing counsel for the respondent authorities.
1, 2, 3, and 4. 5, 2.
This petition under Article 226 of the Constitution of India, the petitioner has
And also
proposed
6,
that
Your Lordship.
the respondent authorities for provincialization of the service under the provision of the Assam Education, between bracket provincialization of service of non-teaching staff of higher educational institution, bracket close, Act 2018, and the Assam Education, between bracket provincialization of services of research and reorganization of educational institution, Act 2017. The learned Council, for the petitioner submits that the petitioner was initially appointed as LDA cum accountant of Dhuburi Girls Junior College, Dhuburi. And he joined on 1/10/2005. And in the year 2000, no, you were then appointed on.
My lord, petitioner number 1 was appointed 2005, 2 was 2008. Petitioner number 2 was appointed on 1/8/2008.
And then the petitioner number 2 was appointed as library assistant to Dhuburi Girls Junior College, Dhuburi. Then he joined in his service on 1/8/2008. And thereafter, the Director of Secondary Education on 4/2/2021 by memo number PC/EROB/67/2021/20 provincialize the service of the teachers, tutors, and non-teaching staffs of the said senior secondary school Dhuburi with it was girls junior college or senior secondary school.
Lordship, senior secondary school, earlier lordship, it was girls college lordship, but by the act of provincialization lordship, all the girls colleges has been renamed as secondary school.
With effect from 1st of January 2021. And though the name of the petitioners were submitted by the principal of the said senior secondary school and recommended by the district scrutiny committee for provincialization of their services under the provision of the Act of 2018, yet their services were not provincialized. Being active, the petitioners approach this court. That notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with ADN legal process. Please the matter after 4 weeks. Madam, you are for
I'm for respondent number 1, 2, 3, 4, and 6.
3, 4, and 6. Then Mr. Devi,
For
5.
respondent number 5, your lordship.
respondent number 5.
For headmaster, they have to take
Principal.
some steps.
That the name of GA Assam be reflected and the requested copies be furnished to us.
Yes.
I'm also appearing for 7.
The post listing.
Although no formal notice is required to be issued to the respondent number 1, 2, 3, 4, 5, 6, and 7. Since all the respondents are represented by their standing counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. Please the matter for course.
Highly obliged.
May our name be reflected, GA Assam.
Okay. The name of G Assam be reflected in the course.
Highly obliged.
Lordship, my learned friend has not served copies of the writ petition on me. I'm the standing counsel KVS. May I pray that he may serve a copy and then I will get the instructions by next Wednesday, Lordships. The matter will be taken up either on Monday or Wednesday next. I don't know how the registry has passed the matter. The means copies are going. Notice.
More confusion.
Copy, that is notice.
Heard, Mr. Your good name?
FZ Mojumdar, lordship.
FJ Mojumdar, Lorded Council for the petitioner, and also heard Madam Sodori for respondent number.
All the respondents.
All the respondents. Sodori submits that she has not been furnished with a copy of the
writ petition.
And as such, she prays for issuing direction to the petitioner to furnish a copy of the writ petition to her during the course of the day. Where is accordingly allowed, the counsel for the petitioner shall furnish a copy of the writ petition to Ms. Sodori during the course of the day. Registrar lays the matter on next Monday In the meantime, my suitor is allowing necessary instruction next Monday from the respondent authorities.
Monday, Lordships. Deeply obliged. RS Choudhury.
May I please, Lordship, my lord? Yeah, this petitioner was the head of the department, he was released. Then he approached this Honorable High Court. Honorable High Court, my lord, page 46 says that what university is clarified that nothing lapses, there is no lapses. Because accordingly, petitioner expected that if the allegation that is to debar some students from appearing exam and the feeding of marks that was unfounded, so he expected that he should be reinstated in the HOD. But page 49, my lord, in the RTI reply says that as per direction of the, as per the verdicts of this honorable court, my lord, C, my lord, C. Regarding the question of headship, the governing body revoke the abide by the resolve to abide by the verdicts of this honorable High Court. My lord, that is why is my lord Article 21. He should have some right, my lord. So that is why he approached again, my lord. Otherwise, with a false allegation, he was removed. And that is interfered by this honorable High Court, my lord. And that at the reply, he should have, my lord, page 31 is the allegation, my lord. First allegation that he has not so cause notice, my lord. Here, two allegation is
Who is for the principal of the college?
my lord.
Who is for the principal of the college?
Guwahati College. Guwahati College, yes. He was the head of the botanic and Guwahati principal of Guwahati College.
Mr. Tobilder, who is appearing for?
Oh, appearing.
Lordship,
Principal?
notice may go, Lordship. Well, I can do. Department cannot. And moreover, Lordship, I would like to point out one thing, Lordship. The Honorable Court has already expunged the at page 46. That entry in the service book already expunged. Now, with the same similar prayer, the direction to was and set aside the order, Lordship. That prayer, whether this is.
That may examine if it is everything is gone. Why should he has right, my lord? And they said the court has silent or like that.
Page 46, Lordship, may use page 46, para 13. Para 13, Lordship.
Yes.
May I read, Lordship? This court, in view of the reply made by the Deputy Controller of Examinations, Guwahati University, is of the considered opinion that there was no necessity on the part of the principal Guwahati College to have made such remarks in service book of the petitioner, which is a stigma and would have an effect in the future career of the petitioner. Accordingly, the remarks made by the principal Guwahati College in the service book of the petitioner, which reads as Dr. Zintu Sharma is released from position of head of the Department of Botany 28/11/22 due to a few lapses on his part related to important college examination works is expunged. Now, Lordship may come to the prayer. 22/11/22, that was. Prayer portion at starts at page is 17.
Yes.
Everything the measure of such shall not be issued, cancelling the setting aside the impugn communication dated 28/11/22. Issued by principal so and so, Bamuni Madam College Lordship. So the or that 28/11/22. But here the expunge was the ACR, the part of ACR, but he is challenging that particular order, Lordship. So notice may go, Lordship, to the principal or the other things.
Since Guwahati College is the main responding party, at this stage, the notice making, we are just comment party.
Heard, Mr.
MJ Burua.
M? M?
MJ Burua, my lord.
MJ Burua, learned counsel for the petitioner, and Mr. Tobilder for resolution number
1 and 3, Lordship.
1 and 3, and Mr. Pizza for resolution number. Six. You are for respondent number 6. No, sorry. Or yes, respondent number 2. Respondent number. The learned counsel for the petitioner submits that the petitioner was working as head of the Department of Botany in Guwahati College and on 28/11/2022, the principal of the college has issued one communication to him, releasing him from the post of head of the Department of Botany on some allegation that the petitioner has not submitted the internal assessment marks of SEC paper of 4th semester in the Department of Botany for examination committee. And on another allegation that the petitioner has prohibited some students of 3rd and 5th semester from appearing in session of examination, which was held in the month of October 2020. And therefore, the principal has handed over SARS of the head of department to Dr. UK Saura on 17th and 20. Against the same communication of the principal, the petitioner has approached this court by filing one writ petition being the petition number 6276 of 2023. And this court higher order dated 23rd/10/2024 was placed to set aside. No, placed to expand the remark made by the principal in the service book of the petitioner. And thereafter, the petitioner has approached the principal, Guwahati College, or
Page 48, my lord. 46.
Yes.
48, my lord, last line, my lord. You partly appoint me in the post of the HOD.
Appoint him again to the post of head of the Department of Guwahati University. But
RTR
no action has been taken by the respondent principal of Guwahati College till that. Being agreed, the petitioner approached this court by filing the presentation. The submission of Mr. Sharma, learned counsel for the petitioner, needs further consideration. That this is obviously issued to the respondents, returnable in forest. However, no formal notice is required to be issued to the respondent number 1, 2, and 3. You are representing 4.
1 and Lordship Department, 1 and 3.
1 and 3, not 4. Not 4. Not 4.
Not 4 Lords, not 4.
Respondent number 3, 1, 2, and 3, since they are represented by their standing counsels. However, notice upon respondent number, however, extra requisite copy of the petition furnished to them during the course of the day. State upon respondent number 4, 5, and 6 be taken by registered post with KD and also by usual process in the list of the authorities.
Obligation.
Obligation.
Upgraded item 37.
Well, I'm sorry, my lord, I have to upgrade because it's for. My lord, this is a matter of transfer. It's a transfer matter where your lordship earlier notice was issued. And there was affidavit which has been filed by the government and we have filed a reply also. If your lordship looks into the writ petition, the impugn order that has been passed by the department is at page 27. Page 27.
Yes.
Just may I read this impugn order? In view of the complaint, received against so-and-so graduate teacher science regarding his anti-administrative activities, which has negatively impacted the overall educational atmosphere, followed by a so-called notice issued from this end, white dated so-and-so, after careful examination of so-called reply and evidence thereof, and to maintain a positive and productive learning environment for the students and staff, so-and-so hereby transferred, posted temporarily with the same grade and pay and other allowances admissible under the rule. Transferred is intended to allow so-and-so an opportunity for his professional growth and to ensure the continuous smooth functioning of so-and-so. So this transfer order now has been put to challenge by us. Now, my lord, if your lordship looks into the transfer, it is based on a so cause. If your lordship looks into the so cause at page 20, first the so cause is at page 20. This is 27/12/2024. This is a so cause. Keep relation to the above quoted subject, it has come to my notice that you were absent in your regular allotted class to deliver teaching to the student without any prior intimation to the undersigned. It has been learned that you have been practicing some unauthorized absence attending the classes for a long time back. Such unauthorized absence if in creating adverse implication to the learning process of the students. It also establishes gross negligence of a duty, dereliction of the authority, and lack of responsibility. As such, you are requested to explain why any such further action should not be taken against unauthorized absence in the class. This is the so-called admission. We immediately replied at page 23. We replied. Manoj will kindly look into it. Page 23. We replied. I have joined so and so. Since then, I have been rendering my service utmost with entire satisfaction, staff, students, and guardians. During my service period, I have never faced any call from any corner and therefore absent from any classes without leave. But surprisingly, it is mentioned in your so-called notice that it has come to your notice that I am absent in my regular allotted class without any your prior permission. It is also alleged that I am practicing such unauthorized absence attending classes from long time back without giving any time and dates, from which I am unable to provide detailed information reply of a so-called notice. Madam, there is no any intentional absence in my allotted classes. There is no any intentional negligence discharging my duty on my part, so and so. So no date, no particulars has not been mentioned in the case, in your so cause. Now, my lord, when this first so cause reply was pending, they have issued another so cause at page 24. They doesn't give any my reply, they doesn't make any mention about why your reply should not be considered. Top of it, they have issued another so called. It has been observed that you have been absent without authorization, have been not been attending school on time. The persistent behavior is a matter of serious concern. Affect the discipline operating efficiency of so and so. Your unauthorized absence and irregularity violates the institutional policy and set a negative precedent. As a faculty member, punctuality and regular attendance are fundamental responsibility. Instruct to submit a written explanation within 3 working days from so and so. So immediately I responded at page 25. Kindly see, this is my response. The second paragraph. That, sir, regarding the allegation of unauthorized absence and irregular duty, I submit I am duty bound and sincere in my respect duties. I attended in the school in time, which is answered through Shiksha Setu application attendance register. I used to go to my class regularly following the timetable mentioned routine displayed. Teacher common room, and I did not do any activities which violate the institutional policy and set negative precedent. I, being a faculty, having the responsibility to maintain punctuality. But on 27 and 28 December, I could not attend in my respect duty as I was suffering from severe neurological problem. On that very day, I went to Gwalpara to visit neuropathy doctor, and the attending physician advised me to take bed rest for at least 1 week, which I informed to the in-charge principal. Copy of prescription is annexed here for favor of your reference. Thereafter, on 30th of December, I went to the school, submitted application before the in-charge principal for granting only for 1 week with effect from 27th of December to 2nd of January, but in-charge principal did not say anything. As such, I believe that my earn leave was granted. Therefore, I used to go back to school from 30th December to 2nd. Lastly, lately, just to take my classes in spite of suffering neurologic problem as the syllabus was not finished, was a matter of strange to say. Earn leave was not granted. A result, I was marked as unauthorized absence, irregular in duty for those days, except those 7 days, neither was absent unauthorizedly, nor I attended lately in the school willfully. Therefore, I seek pardon for the aforesaid lately attended unwilling absence. In view of the above, it is therefore prayed, would be pleased to enough to kindly accept this reply, so and so. I shall never remain so and so. This is my reply which has been given. And the medical, which is at page 21, from 21, we have annexed those medical while giving it to the principal, or the so-called reply. 21, 22, I have given those medical. But my whole case, which I am projecting, if your lordship looks at page 27, this is, they said that it is regarding the anti-administrative activities. I don't mind. Transfer is a condition of service. One has to go. There is absolutely no problem. Now, if your lordship looks into the affidavit filed by the authority concerned, by the department, kindly see. Absolutely, my whole case will be punitive in action. Why, if your lordship looks into 41, the allegation is completely on a different footing altogether. The so cause is on a different line, and if reply, we have given no response. But if they file an affidavit, kindly look at page 41. Public complaint and demand for transfer regarding the behavior displayed by so and so. You see paragraph, my lord, second paragraph. It was also mentioned that so and so, under patronage of previous headmaster, used to exert his influence and fulfill his self-interest, thereby polluting the educational environment of the school. Even after dedicated, honest and dutiful woman took over as a headmistress, after so and so, his efforts to pollute the educational environment through various bases. For example, Sahinur Alam Sarkar irregular and whimsical attendance school, misbehave with other fellow assistant teacher, misbehavior with SMGC member, irregular teaching, unethical activities in the examination hall are some of the numerous allegations.
Oh, that's all right, but going by the Annexer 7, can it be said that it is punitive?
I'm sorry, my lord, Annexer?
7,
Oh, yes.
order.
Yes. My whole, but my lord, my whole case here, by going to the impugn order, which they have passed, I'll submit respectfully that it is punitive in nature, because the so cause they have issued, so cause is in respect of not attending absence. I was not, my lord, unauthorized absence. Kindly see, my lord. Kindly see the so cause. My lord, that I am very aware of it. You can.
No, Mr. Das, you come to this order. Is there any reference to the so cause here?
Yes. Kindly see, my lord. The so cause dated, so cause notice. Kindly see at page 27. Kindly see. Regarding his anti-administrative activity which has negatively impacted the overall educational atmosphere, lordship got it? Followed by so cause notice issued from dated 2/1/2025. Now, second, kindly see, it is at page 24. See 24, my lord. That is my whole case. See 24, my lord. See 24, which they referred to so cause. Kindly see the so cause at page 24. See the so cause at 24. So cause notice for unauthorized absence and late attendance. This is the so cause. That's when you take an action, it becomes a punitive. But this is, you have made a reference of a so cause notice. But the action taken and the affidavit which they have filed is something else. Judgment is second. Kindly see, my lord, how they have done it. Their whole affidavit speaks about something else. My lord, double I checked. Your lordship has asked this. I was looking into the impugned transfer order. I was also wondering, transfer can, they can. It's not necessary. But what is the so cause? You have taken an action transferring on the basis of the so cause. Very well. You can take it. But when you decide to pass an impugned order and you refer to a so cause, this is something unauthorized absence. Where is that? Because affidavit now makes it more clearer, which I read the affidavit. Your lordship looks into the allegation at page 41, my lord, which I already said. Now see the second allegation, which your lordship will find at 71. See 71. Now see the affidavit filed by them 71. I read the first allegation at page 41. See 71, my lord. See, my lord, a meeting of so and so non-teaching staff in the teacher common room of the school under the chair of so and so discuss the below mentioned agenda and of the following resolution. Kindly see resolution number 2 at page 72. The meeting decides to take necessary steps against the complaint submitted by the students against regarding signature taken in the white paper in the examination. What is this, my lord? This is no connection with the impugned order. So cause, your lordship rightly asked, if the so cause has a relevance, has a nexus with my impugned transfer order, so cause has to be in respect of this, not in respect of unauthorized absence. Now they decide, my lord, on the basis of the transfer order is based on my unauthorized absence. Then they decide, okay, I will transfer you. Absolutely no problem. Unauthorized absence also they can transfer. They can transfer. But when you have taken an action, your action is not based on unauthorized absence. Your action clearly is based on something else, on a complaint. Am I not entitled to get a notice? What is a complaint? Is it not a punitive in nature? That's what I'm asking myself, my lord. I'm asking myself, is it not in punitive in nature? Very well, if you have transferred me, I accept. But transfer order has to be based on a so cause that has been issued. Your so cause is based on unauthorized absence. Your action is else. Your lordship has seen apparently on the face of the record which they have filed. It is their affidavit they have filed. First allegation, second allegation. Now kindly see again at page 79. See 79. My lord, kindly see. An SMDC meeting of so and so is held today, the 1st April, in the office of under the chair of so and so to discuss the following agenda. The meeting and of the following resolution, namely so and so, discuss regarding complaint against so and so in respect of taking signatures in white paper from the examiner of so and so. 2, discussion regarding instigating the student of the school by so and so. 3, discussing a complaint against the school to so and so, practical exam so and so. Where is that, my lord? The basic foundation of unauthorized absence, you have issued the so cause notice. Now kindly see resolution number 1. After a serious discussion at page 79 on the complaint against so and so regarding taking illegal signature in white paper from the examinees of the so and so, the meeting scored harshly him from his such type of illegal unlawful act of taking signatures and warns him strictly not to do such kind of work in future. After a long discussion, decide to repair this. So this is the this is what they have done it. Now, my lord, will kindly see at page 89. Head teacher so and so at page 89. Allege anomaly created examining hall by so and so, assistant teacher of your school with reference so and so, learned the incident took place in so during the exam wherein so. So this is what they have done it, my lord. And your lordship, rightly your lordship has asked, what is the impugn? Is it not a punitive? It's not a punitive. But if your lordship looks into the impugned transfer order, it is based on a so cause. That's what your lordship will kindly again look into it. Again, kindly look into it, my lord, transfer at page 27. Transfer is a condition, one has to go, whatever. But this is not a way, my lord, an employee has been transferred. I remain unabsent. Okay, you don't consider my absence, which I have submitted a principle. Yes, you transfer it. But your transfer is not based on this. See, my lord, in view of the complaint received regarding the anti-admission, his negative impact overall, followed by a so cause. So cause is not that. So that's the whole case.
Maybe there may be some mistakes on their part.
But my lord, mistake or
whether this court can exercise a jurisdiction to interfere with the
I'm deeply
scope is
obliged.
very limited.
Yes, I'm deeply obliged that the question that has been asked, that why not a transfer? Because your lordship is exercising a writ jurisdiction under 226. The power of transfer is very limited in nature. Either it has to be some excess of power which has been bound by the authority, which itself will speak some arbitrariness, malafide, and it is a violation of the statutory regulation. Statutory violation, not. My lord, now your lordship knows that there has been approval of the CM within a period, if you transfer, not within that 3 years, before that, within 3 years, then you need a CM approvals. That is one. Second, there has to be some malafide action on the part of the authority. My whole case will rest on the malafide action on the part of the authority A. B is, I term this impugned.
Can it be said to be malified because the inspector has taken the decision in the greater interest of the students?
No, absolutely.
And the
No,
working and
I don't mind.
school.
My lord, I told on the very first day, absolutely no problem. You have taken a decision. But what is the complaint that has been lodged? As an employee, am I not entitled to receive a notice and to give a reply? Forever, it will remain as a penalty way I have been transferred. Suppose you transfer for the greater interest of the student also. And these are the allegations that have been leveled against me by way of a complaint. Of course, I am entitled to get a notice. That's my respectful submission before your lordship.
No, this transfer order may not be the end of the issue. It may be the beginning. Thereafter, they may also start the proceeding
No,
against you.
that's why putting with great respect, my lord. I am just using the word like putting a cart before a horse. With great respect, I am saying, my lord.
Mr. Das, is there any provision for imposing the punishment of transfer in the disciplinary proceeding?
No, your lordship will look how the apex court has dealt this type of cases. How the apex court, what is the law in it? Because I'm with your lordship. The transfer number one is a condition of service. One employee has to go. Very limited in nature under 226. That is very. I have also gone through judgment. It's very limited when your lordship will interfere it. Now it has become more stricter. The why not an employee cannot be transferred, but it has to be within that parameters where an employee has to be transferred. So if it is not within that parameters, my lord, then of course whether by way of a writ whether lordship can interfere or not. That's the issue before this court. That's the issue before this court. And these type of cases, how the apex court has dealt. These type of cases, in what manner it has been dealt. My lord, apparently your lordship has looked into it. There can be a transfer. If this complaint, if your so-cause would have been on any, that means any employee can be transferred, my lord, without any so-cause also. I transfer so-and-so in the administrative agency of service without any so-cause also. Transfer can be done. Absolutely no problem. But when the transfer order, my whole case, if they would not have issued written anything about administrative anti-activities, absolutely no problem. If they would simply say that in the interest of public interest, administrative so-and-so, you are able to transfer. Of course, my lord, my door will be closed. But when I look into the transfer order and it is based on a so cause that has been issued, and a so cause has no relevance with the decision they have taken, then my humble submission before this honorable court will be, it is punitive in action. That's my humble submission.
Okay, you saw the decision of the
Yes.
Supreme Court.
So that's my humble submission, Mike. I'll show one judgment. So much given. 2009 to SCC, page 592. 2009 to SCC, page 592.
Yes.
There, my lord will, I think this, my lord has, this judgment was placed, this judgment was placed by my learned friend, but there was a query which was put by your lordship. I'll clarify what was the query that was put when you reading the judgment. Paragraph 16, kindly see paragraph 16. Indisputely, an order of transfer, paragraph 16. Indisputely, an order of transfer is an administrative order. There cannot be any doubt whatsoever a transfer which ordinarily an incident of service could not be interfered with, save in cases where internally malafide on the part of the authority is proved. Malafide is of two kinds. One is malice in fact and second malice in law. The order in question would attract the principle of malice in law as it was not based on any factor german for passing an order of transfer and based on irrelevant ground, that is, on the allegation made against the appellant in an anonymous complaint. Here, my lord, I'll just use the word, this is not anonymous, it is a complaint. Complaint. But your so-cause connected with the impugned transfer order has no nexus in it. Some irrelevant, my so-cause it on the basis of unauthorized absence. That is not relevant. Then kindly see, my lord, the order in question would attract principle of malice in law as was not based on any factor germane for passing an order of transfer and based on an irrelevant ground, allegation made against the appellant in an anonymous complaint. It is one thing that to say employer is entitled to pass an order of transfer in administrative agency, but it is another thing to say order of transfer is passed by way of all lieu in of punishment. When an order of transfer is passed in lieu of punishment, same is liable to be set aside, being wholly illegal. My lord, when you transfer, they will not write that is a punitive way I am transferring it. By reading of the order, my lord, one has to demonstrate that either it is passed by way or in a lieu of punishment. Only the difference your lordship has asked, I put a question to my learned friend that you have showed the judgment to my lord. And what was the query that came forward by my lord was that this is a judgment which is anonymous complaint. But your order, your particular complaint is not anonymous. But the principle of law will not change, my lord. One is malice in fact and malice in law. One is malice in law, fact and malice in law. My lord, kindly see, I don't mind, my lord. I told that transfer can be passed, but not an irrelevant consideration. If a complaint is being lodged against me, some complaint not connected with the so-called that has been issued, I am entitled to get a notice. Thereafter, I don't mind you decide to transfer me. If you are not satisfied with my reply, my lord, what they could have done it. So-called fine, I replied. Second so-called issued, I replied. There is nothing whispered, neither it doesn't decide on my so-cause. Why they doesn't decide on the so-cause? They realize the mistake. They realized the mistake and they thought that what so-cause we have issued. But they have gone ahead with the so-cause by reply. There is no answer. There is no logical conclusion to my so-cause reply. But directly they come forward with an impugned transfer order saying that for this reason you have been transferred. And which they referred in connection with the so-cause, which has no nexus with the transfer order that has been passed. That is why this is a judgment which I am relying. Now, my lord, another judgment. There is a judgment of the Madras High Court, Division Bench. My lord, settled principle of law, I don't want to, okay, Abbasi, all those judgments are there and when it can be transferred and employed. 16, paragraph 16, kindly see. This is Madras High Court 2013 SSC Online Madras 3958. Para 16. Once it is admitted by the authority transfer was made based on certain reasons of unbecoming attitude of the employee, more particular based on certain incident said to have taken place on a particular date, then the authority cannot exercise the power of transfer on that ground without affording an opportunity of hearing and allowing the employee defend his case. Administrative ground can be put as a reason for transfer so long as such administrative ground do not affect the interests of the employer personally with civil consequences, or such ground do not attribute imputation on the character of the employee. If any of these elements are apparent based on admitted fact, then such ground can no longer be termed an administrative ground. Therefore, we have the firm view order of transfer in this case was passed only as punitive measure to achieve the collateral purpose, and therefore same cannot be sustained in the eye of law as the same has been made in violation of principle of natural. I think only my case is based on this.
All allegations are based on.
Their whole case, there is an allegation on conduct, their case. That my conduct, allegation is based on conduct. That's their case, which they are putting it. So if that be the case, my respectful submission, I think this is the case where the court decides at paragraph 16. Now, my reply, I file a reply to their affidavit which they have filed. My allegation is, my lord will kindly see two annexures. I have annexed and there is specific 9 and 10. Kindly see paragraph 9. Paragraph page 90. My statement, kindly look into it, my lord. In this case, at paragraph 9, page 94, paragraph 8. Paragraph 8. Paragraph 8. Deponent begged to submit. Deponent along with others had made a complaint on 1812 before Director Secretary regarding financial anomalies in the midday meal since March 2024 against the in charge principal respondent number 5. Deponent has been vocal about these financial anomalies and as such the respondent number 5 in connivance with other collaborators has conspired into ousted deponent from the school. The guardians and the local people are submitted a complaint before the Director Secretary alleging misappropriation of midday meal fund. So now these two complaints I have annexed at page 97, which was received by the inspector on 19/12/2024. Kindly see at page 97. This is by all the guardians and specifically my complaint. Yes, kindly see 99. It is my complaint which has been at page 99. Sahnur Alu Sarkar, graduate teacher at page 99. Lordship got it, number 1. And this has been on 18th of December. Kindly note down, my lord, 18th of December 2024. My complaint, which has been lodged against. And this is regarding midday meal, which has been misappropriated. Copy we have given mission director, 99. 100 also at same director of school. So these are the so-called, these are the complaints which have lodged against the in charge principal. And what we are saying that you have done it only because of this. You started trying to build up for transfer, but my transfer is based on some other reasons, and what action you have taken is on complete or different. So, and complaint was filed thereafter the transfer order. Complaint was filed thereafter the transfer order. This complaint was filed, my lord will see 18/12 and 17/1/2025. And the transfer is 27/1/2025. These two complaints was prior to my transfer order. So this is my case, my.
That's all right. This complaint was filed to the Director of Secondary Education.
Yes.
How the principal and the inspector of school
I'm sorry.
aware of the same? Whether you have furnished a copy to them?
No, this is the highest authority. This is the highest authority, director. Highest authority we have submitted. Highest authority, my director. Highest authority I have submitted.
No,
Then I
they
don't
have
know.
Submitted to the highest authority.
Yes, I
but
don't
the-
know what action they have taken against them. I don't know that. That I am not aware whether, but I have, this is the representation.
Then on what basis you were submitting that because of this complaint you have been transferred from that?
This is number one. This is a particular argument, one of the argument. But my whole case, if your lordship doesn't take into all this consideration also for a moment, but my transfer order is based not on the so-called that has been issued. And two, it is a mala fide, punitive in nature because the complaint which they have brought it now by way of an affidavit is completely on a different story altogether. So my case is based on Madras High Court Division Bench, at least the so-called should have been issued. It is punitive in nature.
Yes.
So that's my humble submission.
May it
Yes, one
pleases your lordship.
Pardon?
May it be pleases your lordship. Here, your lordship, I am referring to my affidavit in opposition. Strictly taking you to page 38 of my affidavit in opposition. Subpara 2. Highlighted point, your lordship, irregular attendance and unauthorized absence. According to Shiksha Setu app, which is a biometric geofencing electronic attendance management system, Shahinur Alam Sarkar, who is the present petitioner, assistant teacher at S. Ali HS School, Sukachar, is a habitual and willful latecomer, your lordship. He is habitually being willful latecomer. And thereafter, your lordship, he availed 23 days of casual leave during the academic year of 2023 to 24, which exceeds the allotted 12 days casual leave as per guidelines. Already guideline has been given, your lordship. He already exceeded 12 days. Additionally, the Shiksha Setu attendance record showed that he was a latecomer for 3 days, had unauthorized absence for 5 days, and availed casual leave for 14 days during the year of 2024 to 25, which is the academic year until the 31/12/2024. So here it can be seen that he is being habitually latecomer, and also your lordship, he has not present, your lordship. As per the geometric also attendance management also, it has been clearly reflected. Thereafter, your lordship, below to that, your lordship, paragraph 7, I would like to refer, your lordship, that I would like to read it also. That the deponent begs to state that the petitioner Shri Shahinur Alam Sarkar, which is the present petitioner, was given a show cause notice dated 22nd January 2025, your lordship, where it has been already annexed in their petition regarding his anti-administrative activities and rough behavior, where he has filed his reply against the show cause notice, and as his reply was not found satisfactory, the petitioner was transferred by the order dated 27/1/2025 to Konaimara High School with the same grade and pay. Nothing has been changed, your lordship. Nothing position has been changed and its pay. He is in the same position, just your lordship, because of his harsh and rough behavior towards the anti-administrative person, your lordship. That's why he was transferred to Koinamara High School. The aforesaid transfer order was issued for maintaining better academic atmosphere, for maintaining its better atmosphere, your lordship, to maintain in the school. Your lordship, it was taken notice that transferring him, your lordship, can save this save this academic atmosphere. Thereafter, your lordship, and it was seen by greater public interest.
What is the distance between the two schools?
That, your lordship, only a few kilometers.
Not much. Not much, but I have been told that it is, I have asked now, it's a 15 kilometers. It's not much.
Like to continue. By the aforesaid transfer order, your lordship, the petitioner was transferred with an intention, continuing to page 39 of our affidavit, to give him an opportunity for his personal growth and to ensure the smooth functioning of S. Ali HS High School, your lordship. It is taking into the consideration of the public interest, your lordship, seeing the public interest and, your lordship, anti-administrative activities, and also, your lordship, taking account for the environment, your lordship. He was given opportunity for his personal growth and development, and also to ensure the smooth functioning of S. Ali HS School.
So, whether in the impugn order, you have mentioned about the public interest?
Yes, your lordship.
Where?
Show cause notice, your lordship.
No, in the impugn order at annexure number 7.
Yes, your lordship. That has
Where you
been
mentioned the
reflected,
public
your lordship.
interest?
That has not been reflected.
Not been reflected.
Not been reflected. And also, your lordship, I would like to highlight it some points, your lordship, that affidavit in opposition where we have stated page 36, paragraph 6, highlighted points, multiple complaint petition. I'd like to read it. Multiple complaint petition. Large number of complaints and allegations have been filed against Shahinur Alam Sarkar for his irregular attendance, inappropriate behavior, and deteriorating school atmosphere by SMDC, that is principal, staff members of the school, guardian of students studying in S. Ali HS School, and public and authorities of Federal School. A few examples are enclosed hereby as allegation raised by guardian and public. In this regard, the deponent begs to annex a copy of the public complaint file which displays the behavior of Shahinur Alam Sarkar, and that has been annexed as Annexure A. Page 41. Annexure A. To the honorable election of
Any other point except this, the 2 points?
Your lordship, his harsh behavior, and also, your lordship, if we take that show cause notice has already mentioned because of his irregularity. That is, I have highlighted in page 38, paragraph 2. Stating that that has already been mentioned, your lordship. Irregular attendance and unauthorized absence. According to, I have already read it, your lordship. Your lordship, your lordship, that is my humble submission.
Okay.
It's-
Yes, you are for?
I am for responding number 5, the principal, your lordship.
Principal.
Principal. Lordship, may I plead your lordship, with due respect to my lineage senior, I would like to submit a few facts before your lordship. The petitioner is transferred to the school only a few kilometers away from the school in which he was working.
Few kilometer means?
Nearly 15 kilometers. I'm not sure, your lordship. As per my instruction, it is nearly 15 kilometers. And as per my instruction, the school in which he was working, it has five sanctioned post of science graduate teachers, and there are already six science graduate teachers, including him. And the school to which he is transferred, it has three sanctioned post of graduate teacher, and only one post is filled up. And if he goes there, it will be two posts. Two posts will be filled up, and one will still remain vacant. Lordship, without going into the merit of the transfer order, I would like to submit your Lordship that there are various apex court judgment, your Lordship, which says that transfer is an exigency of the administration, and in very rare cases, it can be interfered with. I am placing here judgment, your Lordship, 2004 4 SCC 245, Union of India versus Janardhan Devnath.
What is the citation? 2004?
2004 4 SCC 245. Janardhan Devnath versus Union of India versus Janardhan Devnath. I'm relying on para 12 and 14. As per my learned senior has pointed out regarding the show cause notice, your Lordship, the parameters are not the same in transfers, your Lordship. That there should be departmental proceeding or not. I'm relying on para 12 and 14, your Lordship. May I read?
Yes.
In para 12, the manner, nature, and extent of exercise to be undertaken by court tribunal in a case to adjudicate whether it casts a stigma or constitutes one by way of punishment would also very much depend upon the consequences flowing from the order, and as to whether it adversely affected any service conditions, status, service prospects financially. And the same yardstick, norm, or standards cannot be applied to all categories of cases. Transfers, unless they involve any such adverse impact or visit the person concerned with any penal consequences, are not required to be subjected to the same type of scrutiny, approach, and assessment as in the case of dismissal, discharge, reversion, or termination, and utmost latitude should be left with the department concerned to enforce discipline, decency, and decorum in public service, which are undisputably essential to maintain quality of public service and meet untoward administrative exigencies to ensure smooth functioning of the administration. Now, Lordship, para 14. The allegation made against the respondent are of serious nature, and the conduct attributed is certainly unbecoming. Whether there was any misbehavior is a question which can be gone into in a departmental proceeding. For the purpose of effecting a transfer, the question of holding an inquiry to find out whether there was misbehavior or conduct unbecoming of an employee is unnecessary. And what is needed is the prima facie satisfaction of the authority concerned on the contemporary report about the occurrence complained of, and if the requirement as submitted by learned counsel for the respondent of holding an elaborate inquiry is to be insisted upon, the very purpose of transferring an employee in public interest or exigencies of administration to enforce decorum and ensure probity would get frustrated. The question whether the respondent could be transferred to a different division is a matter for the employer to consider, depending upon the administrative necessities and the extent of solution for the problem faced by the administration. It is not for this court to direct one way or the other. The judgment of the High Court is clearly indefensible and is set aside. The writ petition filed before the High Court deserves to be dismissed, which we direct. The appeals are allowed with no order as to cost. I'm also playing another judgment, your Lordship. State of UP and others versus Govardhan Lal. I'm relying on para 7. 2004-11 SCC 402. I'm relying on para 7, Your Lordship. May I read, Your Lordship?
Yes.
It is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary in the law governing conditions of service. Unless the order of transfer is shown to be outcome of a mala fide exercise of power or violative of any statutory provision, act or rule, or passed by any authority not competent to do so, an order of transfer cannot lightly be interfered with as a matter of course or routine for any or every type of grievance sought to be made. Even administrative guidelines for regulating transfers or containing transfer policies at best may afford an opportunity to the officer or servant concerned to approach their higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer servant to any place in public interest, and as it found necessitated by exigencies of service, as long as the official status is not affected adversely and there is no infraction of any career prospect, such as seniority, scale of pay, and secured emoluments. This court has often reiterated that the order of transfer made even in transgression of administrative guidelines cannot also be interfered with, as they do not confer any legally enforceable right unless as noticed supra known to be vitiated by mala fides or as is made in violation of any statutory provision. In this case, Your Lordship, the petitioner is transferred with the same grade pay and the same allowance, same pay scale, Your Lordship.
But you tell me, in which part of the impugned order you have mentioned that it was passed in public interest?
Your Lordship.
Is there any mention?
That's it. The Lordship, page 27, annexure 7. The transfer is intended. May I read, Your Lordship? Second para, the transfer is intended. May I read the full, Your Lordship? In view of the complaint received against Sahanur Alam Sarkar, graduate teacher, SRE SS School, regarding his anti-administrative activities which has negatively impacted the overall educational atmosphere, followed by so-called notice issued from this dated so and so, and after careful examination of so-called reply and evidence thereof, and to maintain a positive and productive learning environment for the students and staff, Sri Sahanur Alam Sarkar, graduate teacher, is hereby transferred and posted temporarily with the same grade and pay and other allowances as admissible under the rule. Only temporarily, Your Lordship, only to maintain productive learning environment. And it is also written that transfer is intended to allow Sri Sahanur Alam Sarkar, graduate teacher, Science SLE School, an opportunity for his professional growth and to ensure the continued smooth functioning of SLE SS School.
Okay.
This is my humble submission, Your Lordship.
Okay. For respondent number 4, Madam Burman.
That we already stated in our affidavit, addressing this boundary of ownership.
Commissioner, Lordship, I have not received any instruction, Lordship.
Okay.
My one judgment, the last file, just show one judgment. This is a judgment of Mahinder Singh Gill judgment. Kindly look into that. Paragraph 8, my lord. Paragraph 8. Paragraph 8.
That is well settled, cannot be improved
That's it.
by way of an affidavit.
So what they are trying to improve it, thereby way of an affidavit. They are the public, the order that has been passed, the impugned order has been passed, it has no consonants. And they try to improve by an affidavit, bringing certain new things, whether they will be able to bring it. That's my humble submission, Madam Lordship, that it is a punitive, not in the interest of public, and as such, this transfer order is bad. They can take action, let them take action. Let them pass, but not this way. They want to do something, they can do it, but not by way of this coalition.
Heard Mr. D. does learned senior counsel assisted by Mr. Munir, learned counsel for the petitioner. And Ms. P. does learned standing counsel for the respondent number 1, 2, and 3. And Ms. F. Hussain, learned counsel for the respondent number 5. And Bormont, Madam Bormont for respondent number 4. Argument concluded, order is up.
I'm deeply obliged, ma'am. Deeply.
This petition is regarding non-release of the family pension. Look, initially, the petitioner was appointed as a assistant lecturer in the People Government College, my lord. Thereafter, my lord, he continued from 21/9/1987 to 10/10/2007 in Difu College, my lord. Thereafter, he went to Assam University, my lord. And if lordship turns to page number 43, Annex 10, my lord. For the period that is rendered service for the government of Assam from 21/9/87 to 10/10/2017, under Rule 31, government had decided he is entitled for all the retirement benefits. And on thereafter, my lord, while continuing in his service, the petitioner's husband expired on 27/4/2020. You'll find the date certificate page number 46. So the petitioner was entitled for this family pension. In the meantime, correspondence taken place between the Assam University and the Higher Education Department. And ultimately, my lord, page number 60, lords, you will find the Assam government has released its due for that particular period rendering service for the Assam government of 24,90,982 in a bank draft to the government of Assam University money. And now this part of the amount as well as the family pension by the Assam University has not been released. They are sitting over this particular amount 24 from 23 to 2023. Last 2 years they are sitting over that particular amount which has been released by the government of Assam. And they are also not releasing the family pension which is to be released from their end. That is the case, my lord.
Yes, Mr. Kyle.
Lordship, I may bring for the Assam University. Lordship, matter may be placed on Tuesday. In the meantime, I have already communicated to the registrar because the matter relating to Difu campus of Assam University. So
That's all right. The amount of the government of Assam has released.
No, that is pro rata.
Where is the question of retaining the amount by you?
Understand, Lordship, we cannot retain. Primacy we cannot retain. But Lordship, unless I obtain instruction, if there is.
But you tell your registrar that he has to pay the interest.
I have already intimated to the registrar. Matter may be placed on Tuesday. In the meantime, I have obtained necessary instruction. If there is any problem, they will communicate to you lot. And if amount is to be released, that will be immediately released. But subject to instruction. May be placed on Tuesday.
18.
Heard Mr. S. Borda, learned counsel for the petitioner, and Mr. S. C. Kyle, learned standing counsel for the respondent member. Respondent number 3, 4,
5, 3, 4, 5, and 6.
3, 4, 5, and 6, and Mr. Das for respondent number 1 and 2.
2 is
1 and 2, madam. M. Barman for respondent number 2. In this petition under Article 226 of the Constitution of India, the petitioner, namely Veronica Bora Vermont as Fredro. Issuing direction to the respondent authorities. Especially to the respondent number 3, 4, 5, and 6 for releasing an amount of rupees 24,90,982 rupees. And also for releasing the family pension and other retirement benefits with interest at the rate of rupees 9% per annum. Mr. Bora Learned Counsel for the petitioner submits that the petitioner was serving as lecturer in Diffu Government College from 8/9/1987. The husband of the late husband of the petitioner was serving as lecturer in the Diffu Government College with effect from 8/9/1987 till 10/10/2007 under the government of Assam before joining Assam University Diffu campus.
Six the death certificate.
Hmm?
46 in petitioner's husband expired. My lord, death certificate on 27/4/2020.
And while serving in Assam University, the late husband of the petitioner suffered demise on
27/4/2020.
27/4/2020. And therefore, the petitioner has approached the respondent authorities for releasing the pensionary benefits and other retirement benefit of our late husband, but the same has not yet been paid. Mr. Bora further submits that the government of Assam, through the accountant general, through the senior account officer, accountant general, released a sum of rupees 24,90,982 rupees, being the pension and gratuity for the period he served under the government of Assam. But the said amount has also not been paid to the petitioner till date. And being aggrieved, the petitioner approached this court by filing the present petition with the aforementioned relief. Mr. Kyle Learned, standing counsel for the respondent number 3, 4, 5, and 6 submits that the matter may be listed on
18th. Your lord.
on Tuesday, so as to enable him to obtain up to date instruction. There is accordingly allowed, rest service the matter 18th.
Much.
Oh, my lord.
Matter pertains to non-payment of arrear salary. Salary, my lord, I have worked for that period. Our salary is not given. Pay amount, my lord, period is 26/2015 to 28/2/2017. The proposal was sent many times. The last proposal pays 27, my lord.
Heard Mr. Esari Soduri, learned counsel for the petitioner and Madam Peters for respondent.
I'm appearing for 2, 3, and 4.
2, 3, and 4. And
Ardulva for respondent to 1.
respondent number what?
Notice on motion.
In this petition under Article 226 of the Constitution of India, the petitioner has tried for issuing direction to the respondent authorities for releasing arrear pension, arrear salary with effect from 28/6/2015 to 18/2/2017 for a sum of rupees 4,29,991 rupees. The learned counsel for the petitioner submits that the petitioner was appointed as junior assistant on 19/6/2015 and he joined on 28/6/2015 and thereafter he was promoted to senior assistant in the Latu Higher Secondary School in the district of Sribhumi. And he has not received salaries since 28/6/2015 to 28/2/2017. And though on different occasions proposal was sent to the respondent authorities, but the same failed to evoke any response from the respondent authorities. And last such proposal was sent on 4th of January 2025. Where is the petition and the documents present? Let notice be issued to the respondent authorities. Returnable in 4 weeks. 4 weeks or 2 weeks? 2 weeks.
2 weeks.
No, 2 weeks. However, no formal notice is required to be issued as all the respondents are represented by their standing counsel. However, extra requisite copy of the petition will be furnished to them during the course of the list the matter after 2 weeks. Then in the meantime, Ms. Vedas, learned standing counsel for the respondent number 2, 3, and 4 shall obtain necessary inspection as to the latest status of the proposal sent on 4/1/2025 by the inspector of school SDC. Sribhumi. List after 2 weeks.
Well, the date may be fixed. Madam, one little correction, madam. My name is HR Chaudhary, not HR.
Okay.
Obliged. Same, my lord, issue same.
Same. Arising issue same. Same date, your lordship. Date.
Item 12, my lord.
13 is same.
No, madam, 12 same, madam. Same day.
Order similar.
Same.
My lordship, this case is with regards to non-payment of modified assured career scheme, my lordship. Kindly come to page number 50, annexure J, my lordship. Can I read it, my lordship?
Page number
50, annexure J. With due respect, can I read it, my lordship? With due respect, I understand would like to inform you that I was an Arabic teacher in Bakiwara ME Madrasa and retired on 30/11/2000. That madam, during my service period, I allowed to draw a amount of MACP via order of Government of Assam, order number this. dated 3/10/2020. From then, I had been getting the benefit of MA CPS from 2022 to March 2022, November 2022 till my retirement. But unfortunately, I did not got the area of MACP from January 2017 to February 2020, an amount of rupees 64,022 only, my lordship. So this is his allegation. Accordingly, he filed writ petition before this honorable after getting no reply from that, which is at page 51, annexure K. Page 51, 52, and 53, my lordship. So this honorable court at page 53, my lordship, paragraph number 4, my lordship, and paragraph number 4, my lordship, this honorable court allow his representation to be submitted before the authority, and authority may be that is same authority will dispose of by a speaking order. But in this order, my lordship, there was a mistake at page 51, my lordship, cost title, my lordship. He was shown as retired headmaster, but he is a retired Arabic teacher, my lordship. And accordingly, the same way, petition number 1 also has come before this honorable court for same purpose, my lordship, that she has also not got that MASC is financial upgradation under MASC scheme, my lordship. Their calculating sheet is page 44 and 45, my lordship. Page 44 to 47, my lordship.
So after passing of this order by this court on 27/11/2024, what has happened?
There was a mistake in this order, my lordship.
Thereafter?
There is a mistake for only petitioner number 2 in this case has approached this honorable court, my lordship. On that order, there is a mistake, my lordship. Kindly come to page 51, my lordship.
Yes.
He was shown as retired headmaster, my lordship, instead of retired Arabic teacher. He is a Arabic teacher, not a retired headmaster.
No, that's all right, but there is a mistake in the post title.
Post title, my lordship.
You can rectify it by filing one petition, IA. Why the second writ application?
Second
or
petition,
petition
petition number 1 has also approached before this court, my lordship. In this case, petition number 1 has also approached before this court, my lordship. Safina Khatun. Sultana Begum, my lordship. His letter is a page. Page 40, my lordship, annexure
So
C.
she has not approached the court earlier.
No.
So for the first time, she has.
She has first time in this petition, through this petition.
But in respect of this petitioner number 2, then
that is, I have mentioned in para 8, my lordship, page 7, my lordship.
But again, you have mentioned him as the retired headmaster. Page number 2.
Now he is retired.
Again.
63 years.
Pardon?
Age 63 years, he is retired.
Yes.
60 is the supervision age. In other way also, petition number 1 is grade 4 and petition number 2 is Arabic teacher. Both cannot have the same cause of action. They should file separate petition.
Same under same year they are.
Both person cannot claim together.
My lordship may
come to page number 2 of the petition.
Yes, there is a little mistake is there, my lordship. So all the except they are all in. I have mentioned in page all there. I have mentioned Arabic teacher, my lordship.
No, you commit some mistake, and thereafter again you will filing the writ petition.
Can I correct this one, my lordship, by filing?
Okay. As prayed for by Lord Counsel for the petitioner, SSL leave the matter after a week so as to enable him to file necessary to make necessary correction in the cost title of the writ petition. Here is accordingly allowed. SSL leaves the matter after 1 week.
And being item number 4.
Earlier, and we got directed to file affidavit manner. Because we have objection on that interim prayer manner, that's why manner. Manner.
This is a matter wherein the petitioner number 2, she is a class 8 student. Interim order is already there, my lord. This honorable court is pleased to pass the interim order, directing to her to allow her to continue, directing the respondent. My lord, the petitioner 2, before your lordships, is a class 8 student. She was sought to be issued transfer certificate from Sainik school on the alleged ground that one boy came to her quarter, that is father, her father is also a teacher, came her to meet in the quarter when the parents are not home at their home. So on that pretext, they decided to issue transfer certificate on disciplinary ground to the petitioner. Now, the father, as petitioner number 1, since she is the minor and she being a petitioner number 2 has approached this court, this honorable court was pleased to pass an interim order directing the respondents to allow her to her studies in the school. Now, today they have filed an affidavit. It's a 2-page affidavit. Doesn't deal with any of the averments made in the writ petition. Perhaps maybe because of the reason that this honorable court did not issue notice on the last occasion. Maybe for that reason.
Yes, notice.
So this 2-page affidavit, Miller, will not lead us to anywhere because I have made detailed averments in the writ petition. You are bound to answer those averments because I have challenged on the ground of Miller violation of principles of natural justice. No show cause notice was given. The inquiry they have conducted, Miller, that inquiry report was not furnished. Apart from that, there was perversity, allegation of perversity, Miller, ground of perversity. That also, so perhaps, Milord, they are required to file a detailed affidavit. This 2-page affidavit, Milord, will not lead us anywhere.
Yes, madam, you file detailed affidavit.
Notice may be issued.
But I can file a detailed affidavit, but I'm on the interim pair, my lord. Kindly.
Interim pay already granted.
Yes, my lord, because that's why my lord, the notice has not been issued on that day, my lord. That is in most of the.
Issue notice.
No, my lord, my lord, kindly then fix on Monday. I'll file tomorrow I'll file my affidavit, my lord. Kindly fix on Monday, my lord. Because from the next session, my lord,
No, ma'am,
the
why my
interim
friend
interim
is
will continue, then my
notice
lord.
is what? Otherwise, also, if your lordship
We-
wants to
I
get the
said-
matter, it has to come up for admission, my lord.
But the urgency is that, my lord, from April, that new session will come. Before new session, my lord, that matter may be hard, my lord, because that will.
Let's look at who is responsible for the same.
My lord,
But your detailed affidavit will issue notice.
No, my lord, then Monday.
Without hearing, no, without issuing notice, can you hear the matter?
Then my lord, fix on Monday, my lord, we'll file affidavit by tomorrow, my lord.
No, notice has to go.
Okay, we will issue notice.
Notice,
Okay,
take-
okay.
I'm taking note.
Heard Mr. S.K. Das, learned counsel for the prisoner, and also heard Ms. A. Gayon, learned standing counsel for the respondent of purpose. Having gone through the order dated 27/2/2025 and 3/3/2025, I find that no notice has been issued to the respondent authorities. Accordingly, it is provided that notice be issued to the respondent authorities returnable on next Monday.
Monday.
They'll file a detailed affidavit.
Yes, my lord, I'll file, my lord.
Let
By
there be an
tomorrow.
observation by your lordship.
Yes, my lord.
Monday.
Seventh.
Okay, Monday.
Yes, my lord.
However, no formal notice is required to be issued since Ms. Gayon has entered appearance and received notice. But the extra requisite copy of the petition will be furnished to her during the course of the day. Ms. Gayon submits that she has already filed an affidavit, but the same relates to granting of interim pay. by this court. But it appears that on 27/2/2025, on the day of motion, interim order has already been passed by this court. That is, Ms. Gayon submits that she will file detailed affidavit on next Monday and press for listing the matter on Monday. They are allowed to list the matter on Monday.
Look, the interim order may continue.
Till then, interim order pass earlier shall continue.
Tuesday na থাকে Monday. Highly obliged. Much obliged.
Kindly adjourn for the timing, my lord.
Why?
My lord, youngest counsel, my lord, is on leg, my lord.
Who is the youngest
F
counsel?
Hawk, my lord. F Hawk. My lord, may be taken up at 2 p.m. My lord, I am not engaged. I am not in the case, my lord. Case is
At 2 p.m. then, okay.
at 2, my lord. Obliged.
Meet legal lawsuits. The petitioner before a lawsuits is the father is working as a get for employee, my lord. He died on 31/3/2017, my lord. After death of his father, he applied for the post of Gate 4, my lord, on 22/5/2017, my lord. That is then lordships state level committee rejected the pair of the petitioner because he applied after 1 year, my lord. But unfortunately, my lord, I approached when I received the state level committee, my lord, I approached this honorable court. But after that, I received district level committee minute, my lord. It is shown that he was recommended in the post of, my lord, Gate 4 of Tamulpur Commerce College, that is page 40, annexure 14, my lord. But in this case, my lord, unfortunately, they have typographically mistake that the date of application it is shown as 5/11/2018. Date of application, my lord. But the petitioner applied on 22/5/2017, my lord. Though his name was recommended, my lord. Lordship got it, my lord. Date of application, I have annexed, my lord.
5/11.
5/11, yes, that is annexure 5, page 25. 22/5/2017. Received a copy to district level selection committee. That is page 40. In page 40, district level committee, my lord, the date of application, it is shown as 5/11/2018. So the state level committee has been rejected because it is shown that he has been applied for the post after 1 year, my lord. That is my case, my lord.
Yeah, that's all right. Director, did you file any representation that there is a mistake in the date of the resolution of the district level committee?
Yes, my lord.
When?
The date of application, lordship, kindly peruse the petitioner candidates for grade 4.
No.
A.
After rejection of your candidature.
Yes, my lord.
Post
Yes.
by the state level scrutiny committee.
Yes. State level committee was.
Did you file any representation?
Did you file it? No,
that there is a mistake in the date?
No. I have not filed because that he didn't know that his application was wrongly inserted in this district level committee, my lord. Then he received when he applied for that RTI, then he has come to know that state level committee was rejected, my lord. So he did not make any representation before anyone, my lord.
Directly he approached this court.
Yes, my lord. I have approached this court to correct it, my lord. Give direction to correct the date of application. the date of application of the petitioner. Because it is wrongly inserted in the district level.
That is your only pair.
Yes, my lord. So that because he has already been recommended, Lordship kindly peruse the last para. Name of the recommendation of candidate. Dangdang Bosumotari recommended against the vacant post of grade 4 of Tamulpur Commerce College. It should be corrected, my lord. Otherwise, the state level committee rejection order will be remain same. So if it is corrected and send the matter to the state level committee, then it will be.
At this stage, issue notice, Lord.
Pardon?
Lordship may issue notice, Lordship, at this stage, Lordship. We have to take instruction, Lord. And Lordship,
No, there is a apparently mistake.
Is
in
made
the
by
date
the
of
opposite
application.
party. Yes, my lord.
So if we dispose of the petition by directing to make necessary correction
Yes, my lord.
in the resolution of the
District level
district
committee
level
and send to
committee,
the state.
thereafter the committee will consider, state level committee will consider it.
Yes.
no, Lordship, by the notification 18 September, Lordship, 2024, Lordship. That
No, this case is prior to the
Prior to this
the
notification. If he would have been appointed, my lord, he will never come to
But
the court.
Lordship, that
If it is
notification-
they who will insert it in correct date.
That notification is under challenge, Lordship, that
Maybe.
hearing is going on, Lordship. Then no, Lordship, at this stage, Lordship, issue notice, Lordship. We have to take instruction, Lordship.
Then my lord, next week, let them bring instruction. Let them bring instructions why they have been putting the wrongly, my lord.
Yes, Lord.
Inserted his application's date, my lord. I need only that correction, my lord.
Heard Ms. K. David, learned counsel for the petition.
Hey, that is a long robust.
And Madam Borman for respondent number.
Waiting for respondent number, Lordship.
Respondent number 3, 4. Then
He's
Madam-
appearing from state level
Madam
committee
one.
only.
In this case, Lordship,
No, this is a district from the Bodoland, my lord. She is appearing on only for state level committee.
ETC, Lordship, she
I am appearing for 1, 3 and 4.
1, 3 and 4. Okay.
She has done mistake.
Grievance
I'm Mullabad.
being sought to be addressed by this court in this petition. Under
Application Mullabad, হ্যাঁ, আমার
26
সাথে
of the Constitution of India is that
20 তারিখ লো।
the father of the petitioner, namely Baburam Basumotari,
21
was working as a grade 4 employee of Tamulpur Commerce within bracket Junior College. And he died in harness on 31/3/2007. After the death of his father, the petitioner and other family members left with no other livelihood to maintain them. While the petitioner filed one petition on 22nd May 2017 for being appointed on compassionate ground to the principal Tamulpur Commerce within bracket Junior College for consideration of his case for appointment to any grade 4 post. Thereafter, on 13/10/2017, the principal Tamulpur Commerce College forwarded the application of the petitioner to the inspector of his school, BDC Masalpur Paksa. Thereafter, on 5/11/2018, the Director of Education, Bodoland Council, forwarded a letter to the inspector of his school and requested him to place the matter before the district level committee meeting. Thereafter, on 2/5/2019, the inspector of his school, EDC, must also inform the Commissioner and Secretary to the Government of Assam Education Department regarding the proposal of completion and appointment of the petitioner. Thereafter, on 31/12/2018, the district level committee recommended the name of the petitioner for being appointed as the grade 4 employee in Tamulpur Commerce College and shown the date of application as 5/11/2018. But in fact, the date of filing of the application was 22nd of May 2017. The district level scrutiny, district level committee then awarded the minutes to the state level committee on 4/1/2020. But the state level committee has rejected the petition of the petitioner on the ground that the application was not submitted within 1 year from the date of his father. It's very learned counsel for the petitioner submits that. In fact, the petition was filed by the petitioner on 22nd of May 2017. But the district level committee has district level committee recommended his name, shown that he had filed the application on 5/11/2018. And as such, the petitioner has approached this court to issue direction to the respondent authority for making necessary correction in the date of filing of the application and thereafter to relegate the matter to the state level committee for further consideration. However, Ms. Borman, learned standing counsel for the respondent number 2.
C is not taking instruction. BTC, I'm appealing only for chief secretary. That's my number 2.
Respondent number 2,
That's my number 2.
to some state. This is there's only notice maybe, and she may be, and she will obtain instruction. And further, she submits that the government has issued one completionary scheme. And the scheme is being challenged before this court. And the matter is still pending. Taking note of the submission of learned advocates of both the parties, it is provided that notice be issued to the respondents, returnable in 2 weeks. Returnable in 2 weeks. However, no formal notice is required to be issued since all the respondents are represented by their engaged standing counsels. However, it's the requisite copy of the petition will furnish to the course of the petition. This is a matter on
21 22 weeks, no? Well, till then the post may not be filled up. That post which has been recommended by the district level committee shall not be filled up, my lord.
Is there any proposal to fill up the?
No, my lord, it is recommended against the vacant post that may be filled up by the someone, my lord. That is why they have been putting. Where there is
Madam.
The district level committee has recommended in the Tamulpur Commerce College, my lord. Tamulpur Commerce College, my prayer before your lordship is that post may not be filled up. That's enough, my lord.
Madam, they cannot fill up the post in view of the notification issued by the
No,
government.
that is why they have put my application's date is different.
In case of compulsion, the referral cannot be claimed for particular post.
No, I have not claimed that particular post. It was recommended by the district level committee. You are incorrect, my dear colleague.
We will consider your prayer on next day.
Yes,
Let them obtain instruction. In turn, their petitioner will be considered on next day.
Hey, come. Hey,
But in this case, my lord, the petitioner is working as a lecturer in the Udalguri Polytechnic since the year 2021 under Regulation 3F. And the services of the petitioner has been extended from time to time. And the latest order is at page 29. My lord, in the meantime, my lord, an advertisement was issued, my lord, on 38th of December 2024 at page 38 for 96 number of postmen.
Yes.
And thereafter, my lord, the petitioner, since the petitioner is serving in the Polytechnic for the past 4 years, the petitioner has submitted an application before the concerned authority at page 42, my lord, dated 6th of January 2025, on the ground, at page 42, my lord. On the ground, my lord, that the petitioner is on 40 years of age and as the cutoff mark is 38, so he prayed for condonation of the relaxation of the age, my lord. So that application was, there was series of correspondences and finally an order was passed by the Director of Technical Education at page 47. That is on 22nd of January 2025, whereby it was informed to the principal of the Udalguri Polytechnic that there is no rule as such for relaxation. So to that effect, my lord, I have filed a writ petition, my lord. And in the meantime, the written test has been held, my lord, for the examination. I have applied, my lord, on 7th of January, 14th of January 2025, I have applied. But the written test has been held, but as of now, the result has not been declared. My limited prayer, my lord, is that it is a covered case, my lord, and as per the rules of the Assam Technical Education Service Rules 1981, my lord, there is a provision under Rule 28, my lord, whereby the government can provide for relaxation, my lord. Under Assam Technical Education Service Rule 1981, there is a provision which provides for relaxation, my lord. And thereafter, my lord, there are similarly situated case, my lord, of this of a coordinate bench of this court, my lord. Whereby in that case, my lord, the petitioner was directed to submit an application before the concerned authority, and the authorities will decide as regards the prayer for condonation of the age. And the rule has been quoted in that judgment, my lord. And moreover, my lord, as per the judgment of Uma Devi, which has been again reiterated by the apex court in other case, my lord, of Satya Prakash, reported in 2010 for SCC, it has been held, my lord, that if the persons are working, my lord, they can be provided relaxation, my lord. If the persons are working, they can be provided relaxation, my lord. The relevant para is at para 1415, my lord, of the Supreme Court judgment, my lord. So my limited prayer, my lord, is that since the results of the written test has not been declared as of now, I may be allowed to submit a representation before the Secretary of the Technical Education Department.
No, whether you have appeared in a written exam.
I have appeared, my lord. The result has not been declared.
Yes, that's it.
Yes, well, on that line, my lord, because the competent authority is the secretary, my lord. On that line, if the petitioner submitted a presentation before the secretary, my lord, may decide, my lord.
In terms of this order passed in Rupert Sharma, my lord, 1289 of 23.
Because of this representation.
Earlier, my lord, the petitioner has applied before the recruitment board, which is not the competent authority. Thereafter, my lord, the petitioner applied before the director. Director is also not the competent authority for relaxation of age, my lord.
Who is the competent authority?
Secretary.
Secretary, my lord. He is respondent to, my lord.
And you have filed the application
On 6th of January 2025, my lord.
page number?
Age, my lord, 42, my lord, 42. I had submitted to the principal, to this chairperson, Assam Engineering Service Recruitment Board. Then the principal forwarded to the board that day itself at page 43. Then at page 45, we have submitted a detailed representation before the director. And a copy was marked to the secretary at page 45.
So the rule quoted in the impugned judge, or no, in the judgment dated 10/3/2023. This rule is from which?
The Assam Technical Service Education Service Rule, page 741. This book. And the relaxation is at page Assam Technical Education Service Rules 1981. Rule 7 provides for the age limit, and the relaxation is at Rule 28.
Oh, Mr. Does is this rule not applicable in case of the petitioner?
Sorry, my lord.
Is this a rule not applicable in case of the petitioner?
My lord, that is to be seen by the, my lord, authority, my lord. Otherwise, there is a provision, my lord. Admittedly, there is a provision for.
Then where the this respondent?
My lord, it is applicable, my lord. Polytechnic, if my lord may kindly see the note at page 741.
No, that's all right.
Engineering College and Polytechnic.
There's a page number 47, annex 12. There is no provision for condonation of age. If the rule provides for, then whether this person who passed this order, who has authored this letter, is aware of the rules. Then we'll pass the order. This one.
It may be disposable, but we may be allowed to file a representation within 2 weeks, my lord, because or within a week, my lord, because the result as of now has not been declared.
Within a week from today?
Yes, my lord. And thereafter, they can decide within a time frame, my lord, on my representation. Okay.
কোনটো 1951 এখন ওয়েব আছে না রেজিস্ট্রেশন
Made pleader lordship. My lord, in this matter, my lord, regarding all the petitioner is stipendary feature, my lord, and there is a condition in the appointment letter. Your lordship go to it, my lord. Page, my lord. 44, my lord. serial number 1, my lord. Annexure 3, my lord. So subject to discharge without any notice and without assigning reason, there was a Bina Setia Fukon that are so and so is temporarily appointed as a stipendary teacher, my lord. And next para, my lord, para number 1. Initially, she will get a monthly stipend of 900 only per month. Subsequently, she will be deputed under basic training for a period of 1 year, where she will get subject to the availability fund, deputation allowances, so and so, so and so. And thereafter, my lord, this was first on 16/12/1999, my lord, and she was deputed to the basic training course, and she completed page 56. Sorry, 54, my lord. And thereafter, my lord, she has completed basic training, and thereafter she received a scale of pay, my lord. And thereafter salary was stopped. Thereafter a scanning committee is coming, and so they appear. Page 111, my lord. 111. This is more important, my lord. This was the regularization order, my lord. Annexure 20, page 111, my lord.
Page number?
Page 111. 111.
No, this as per this annexure for page number 48, she has undergone basic training course.
My lord.
Thereafter?
Thereafter, my lord, he was receiving regularly, and thereafter salary was stopped. And thereafter, my lord,
When the salary was stopped?
salary was stopped from my lord, 2000 till my lord. Having regulation feature in my proposal. Sorry, my lord. 1/1/2003, my lord. My lord is complete basic
Page
training,
number?
my lord. And thereafter, my lord.
No, that page number?
My lord. In prayer, my lord is given. Thereafter 90 in petitioner successful complete with scale of pay was with effect from 2003, my lord. And thereafter, so many of courts order there, my lord. And my lord, please may kindly see, he was regularized, my lord. Please. This is the main issue of the debt, my lord. Regularized on Annexure 20, my lord, page 111. Her name is serial number 28, my lord. Page 112, my lord. Below, my lord. Bina Setia Fukon, my lord. All the petitioner came before the honorable court for old pension, my lord, along with my lord arrear salary, and page 114, my lord. All the petitioners came, my lord, is Jibon Mohanto and others, my lord. 114. And honorable court by order dated, my lord, 30/10/2019. Annexure 117, my lord. My lord, honorable court directed 1118, para number 7, my lord. Before that, my lord. As regards this claim, it has been submitted and authorities have already declared those teachers who passed junior basic training course before 25/1/2005 shall not be covered under the new pension scheme and evident from the so-and-so. Accordingly, this court is of the view that since the petitioner had obtained junior basic training 2002.
So when her service was regularized?
Regularized, my lord. Annexure, my lord, 20, page 11. triple one, my lord, on 11 April 2018. Okay. And my lord, some of the petitioner came before the honorable court, and honorable court directed to give the all, my lord.
This order was passed on April 2018
Yes,
with effect from?
with effect from, my lord. From the date of the, my lord, appointment issue against vacancy so and so, the convict so and so, from the date of order, my lord. Who are recommended screening committee so and so, subject to the satisfaction so and so, is police. And serial number 4, my lord, Jiban Mahanta, my lord. Your lordship got it, my lord. Serial number 4. Jiban Mahanta and others came before the honor. Jiban Mahanta, page 114, my lord. And honorable court directed to pay area as well as the covered under old pension scheme, my lord. 118. And government person to contempt, my lord. Government allowed, my lord, page 120. Government allowed there, my lord, in view of page 120, my lord. In view of the above fact, it is observed that since the benefit claimed by the present petitioner has already been extended to the similar situated teacher co-petitioner, therefore, you are requested to kindly comply with the Honorable Guwahati High Court order so and so, case number so allowing regular pay scale and instead petition with effect from date of their passing junior basic training, along with arrear, the regular arrear of the order till the order of the regulation 11 April 2018, my lord, as well as allowing them to govern under old pension scheme, my lord. And my lord, they are receiving what happened, my lord, in this case, my lord. 7 petition, 7 of the one entire, my lord, regulation 7 was not receiving. There came before the honorable court. Already, my lord, 2 cases was disposed of, my lord. That is there is an order, my lord. The 69993 of 2024. There is an order, my lord. 69993 of 2024. And one Krishnakanta Das, he is the regularized serial number 27. And next page, Rajesh Jadhav, serial number 13. And next page, 3, my lord. Banikanto Moran, 22, serial number. Nilima Gugoi, serial number 1. These are come before the honorable court. Now we're going to pass the recently on 20/2/2025, my lord. And honorable court mentioning Jiban Mohanta as well as, my lord, order judgment of 118, page 6, my lord. Page 6, serial number 6 para. Another judgment was passed on 31/3/2023 in 2006/403 of 2021. These are the, my lord, specific orders, serial number 1, my lord. Your lordship got it. The read petitioners who have come within the fold of stipendiary teacher are entitled to the benefit of Rule 69. They are not covered under the new pension scheme. And this said petitioner also entitled circular GPF. This said petitioner would be entitled and other pensionary benefit. On the basis of 2 judgment, my lord, honorable court, my lord, allowed serial number 7. Though it is a prima facie appears that the petitioner case is covered by this above judgment and order, this court is of the view that by way of abundant caution, the state respondent should be given liberty to verify the particulars of the petitioner. Accordingly, respondent shall verify the petitioner particulars, and if it is found that the petitioners are entitled benefit provided in para 118 of the judgment and order 31/3/2023, passed in so and so, same should be provided to the petitioner. The entire exercise should be concluded within a period. So I pray before our lordship with a similar order. And last occasion, my lord, there is an order, my lord, dated 30/10/2019, my lord. Oh, sorry, 6/3/2025, my lord.
That order is not available here.
No, is there, my your notice it, my lord. This case, my lord. By Honorable Justice, my lord. My lord Justice. Also, my lord. No, it's court order, just court order. Oh, serial number. Okay, order is 6/3/2025. And
But
other
those
2
others-
years dispose of this there, my lord, file along with that, my lord. Same order I pray before lordship. Both cases are disposed of. Same regularization, same appointment, my lord. WPC number 3091 of 2024. And WPC number 294 of 2024. Both cases are there, my lord. So I'll be allowed to.
For
say-
respondent authorities,
Paying for the respondent authority, my lord.
No, hetu nohoy na.
My lord, there's an order dated 6/3/2025.
Order 22/2025.
Appearing on behalf of Mr. N.J. Khatulia, my lord. My lord, there is an order dated 6/3/25, my lord. Regarding that Punima Hore judgment, my lord, there's some this thing, my lord. Mr. Khatulia was supposed to verify it, my lord. My lord, can it be taken up on some other day, my lord? Because he's basically dealing with this matter, my lord.
Mr. Katone is absent today.
No, he's absent today, my lord. Couldn't make it today to court because for some personal difficulty. He's there, if your lordship sees the last order, 6/3/25. He has mentioned that.
Same appointment letter, same regularization, both name is, all our names are there, the same.
The Purnima Hore judgment, my lord, regarding stipendary teachers. My lord,
My lord, in this judgment, my lord, para number 4, my lord, lordship, my lord, para number 4. Para number 4, my lord, this is judgment. Mr. R.K. Borpujari, Learned Counsel for the Finance Department, and Mrs. S. Sutia, Learned Counsel for the Elementary Education Department, submits that the case of the petitioner appear to be covered by judgment and order dated 31/3/2023 and 30/10/2019, passed in Purnima Horo Supra and Jiban Mohanto respectively. However, they pray that the state respondent may be allowed to undertake to verification of the petitioner particulars prior to the extending the benefit of the judgment and order quoted above, my lord. So, my lord, they says that they, and also want to verify, and they also stated that it should be certified copy along with the writ of the writ petition may be submitted in last line, my lord. The entire exercise should be concluded the state respondent within a period of 3 months from the date of receipt of a certified copy of this order, along with the copies of the writ petition. They verify by the government person to the Jiban Mohanto, Purnima Hore, because of that is the stipendary teacher, and regularize the same way all are receiving getting benefit, my lord, in Jiban Mohanto's case, my lord. And authority also verify, my lord, they are receiving all benefits. So I may be entitled because of that. If honorable court permit me, my lord, 1111, my lord, and except with the regulation order, my lord. Nilima Gogoi benefit, Rumi Dotto got benefit, my lord, Jiban Mohanto also got Jiban Mohanto. All are my lord. His serial number, Kistokanto does serial number 27. And Rajesh Jadov 13 serial number. So their honorable court dispose of the matter, my lord. In light of that matter, they verified matter.
oh, why should we adjourn the matter then? If it is a covered case?
Similar,
My lord, I leave it to your lordship.
similar.
Whereas, my lord,
Before
can wait,
passing the order,
have it on some other day, my lord. Lordship can have it on some other day. Mr. Khatuna will be there, my lord. He'll be there, my lord. On that day, he'll, my lord, appraise your lordship regarding the matter, my lord. Because today, my lord, some personal difficulty. The finance council
I
also,
think
my lord.
you
Mr.
are also
Babu
standing
Jha-
out to be the
I am, my lord. I am standing counsel, my lord, but he's been handling this. The file is with him, and I'm using the second copy actually. And the finance council is on legs, my lord. Couldn't come because of some, my lord, unforeseen, my lord, circumstances. So, my lord, it won't be right.
On last occasion, my lord, 6/3/2025.
We'll keep the matter as part
Yes, my lord.
next week.
On Monday, my lord.
Learned counsel for the petitioner and Mr. A. Fukun, learned standing counsel for respondent number.
My lord, respond number, my lord, 1, 2, and 3.
1, 2, and 3, and Madam for
Respondent 5, your lordship, on behalf of Mr. Arbor Pujari.
respondent number 5, appearing on behalf of Mr. Arthur Pujari. Learned standing counsel for the finance department. Third and part, lays the matter on next Thursday.
Monday, my lord. Next.
No, hearing day.
Third.
Next Thursday.
Next Thursday.
This is the list the matters part.
Time being item 40.
My pleasure, Lordship. Lordship, matter relating to family pension, Lordship. The petitioner is the first wife of her deceased husband, Lordship. And subsequently, Lordship, the second wife, Lordship, and he is a government employee. And she has no any objection if the concerned authority granting pensionary benefit to the petitioner, Lordship. And kindly come to page number, Lordship, and declaration made by the second wife, page number 25, Lordship.
Yes.
And here in this case, Lordship, the second wife, and he made his declaration, and she has no any objection if the pensionary benefit goes to the first wife and the present petitioner, Lordship. And in this regard, Lordship, they kindly come to page number 24, and the representation was made before the authority, Lordship, but not considered, Lordship.
Page number
24, Lordship, in action 9. Representation.
30.
24, 24, Lordship. And otherwise, the second wife, Lordship, and she government employee, Lordship, having no any objection. And so, my lord, my limited prayer, Lordship, representation may be considered, that direction may be given to the respondent, Lordship, that must, Lordship.
Yes.
Today your lordship will issue notice.
Pardon?
Today your lordship will issue notice.
Today.
Today your lordship will issue notice. Your lordship will allow us to verify. Then your lordship. I have nothing. I am for the AG, lord. I'm not for the accountant.
But otherwise, Lordship, only representation that maybe.
The representation will be disposed of by
Well, that is to be done by
director of pension.
That is to be
Elementary education, Lordship. Respondent number.
Elementary education. Respondent
Lordship.
number.
Respondent number, Lordship, 7.
Respondent number
7, Lordship, 7.
7.
The principal.
7 is the principal.
And the respondent number, Lordship, 3.
They have not made a point.
Elementary education is the respondent number 3.
3, Lordship. So otherwise, there is no dispute at all.
If we issue direction to respondent number 3 to dispose of the representation, whether we should issue notice to you.
No, that's what I'm saying. That let a note. See, he has waited so many days. He can wait a few more days. Let a notice go. We'll get the instruction, and then your lordship will discuss. Otherwise, we have nothing more to say.
Petitioner is very old.
One person is getting, and it has to go to another person. Otherwise, we have
71 years later, Lordship.
Now, who has been receiving the pension?
No, Lordship. Now, not just her husband is died in the year of 2000. Now pending, Lordship. Not giving, Lordship, anyone. But
When the person concerned retired,
husband, Lordship.
when?
The 36 2014, Lordship, in retired, and expired on, Lordship, 30
And
11
till then,
2024. 6/8 2024, Lordship.
Till today, the pension is not set.
Not held up, Lordship. 6/8 2023, Lordship.
Yes, madam. Are you representing this respondent number 3? 3. No, there is no problem in issuing notice, but his pair is to dispose of the representation in the light of the declaration made by the second wife.
Second wife is not entitled, Lordship. And she is a government employee, Lordship, and in para number 6, Lordship. And para number 6 last, Lordship, and she is a government employee holding the post of UDA.
Let's notice go at this.
Lordship.
On next day, we will see.
Lordship.
Heard Mr. F. Learned Council Board of Petition. And Mr. Your good name, please.
D. Bhattacharya for respondent 5.
AG Bhattacharya, learn extending counsel for the respondent number 5, and Madam Sophia for respondent number 3, and Mr. Derry for
1 and 4.
1 and 4. 1 and 4. This petition under Article 226 of the Constitution of India, the petitioner, namely Helena Marak, has spread for issuing direction to the respondent authorities to sanction and pay the family pension of the petitioner by issuing pension payment order. The learned counsel for the petitioner submits that the husband of the petitioner. No, the petitioner is the first wife of late Elliot Phil Sangma, who was working as principal of PTC Dudnoi Gwalpara. And he retired from service. He was also granted pension by PPO number 912211219968 till his expiry on 6/8/2023. Till the date of his expiry on 6/8/2023. Thereafter, the petitioner has obtained next of kin certificate dated 29/11/2023. And thereafter, say, filed on representation before the authority concerned on 30/11/2024 for releasing her pension. And also, she has enclosed the no objection certificate given by the respondent number 8. But the same failed to evoke any response from the respondent authorities. Being aggrieved, the petitioner approached this court by filing this petition with the aforementioned relation. Let notice be issued to the respondents returnable on let us fix it that after 2 weeks. But there are some other respondents also.
There is a private respondent.
After 4 weeks then.
3 weeks,
Correct.
if possible, 3 weeks and
Okay.
first, before Bihu vacation, Lordship.
Okay. However, no formal notice is required to be issued to the respondent number 1, 2, 3, and 4, and 5. Since they are represented by their standing counsel, however, expedited copy of the petition will be furnished to them during the course of the step upon rest of the respondent be taken by registered post with AD and also the usual process within 2 working days from today. List the matter after 3 weeks.
Can the Lordship date may be Lordship? Published.
20.
Published.
17.
It is a lordship. The petitioner before lordship is the assistant librarian working in a particular college. He is aggrieved by the disproportionate pay with the head assistant. The same case lordship issued notice day before yesterday, my lord. That the petition is, my lord,
WPC 1322 2025. WPC 1322 of 2025. The Lordship may issue notice and take this matter along with the petition, my lord. Issue is same, my lord. They are agreed by the, my lord, pay scale and grade pay given to the head assistant. Though they
The
are,
other day method.
my lord. Rupam Bura Gohai.
Notice may be issued.
Part makes Mr. I. Soikia, learned counsel for the petitioner, and Mr. Toby Garrett for respondent for
1 and 2 lots.
1 and 2.
Lots.
Secretary, finance, not there.
I'm for respondent of higher education 1 and 2 and 3 for finance. I go move on.
This petition under Article 226 of the Constitution of India, the petitioner has tried for issuing direction to the respondent authorities to upgrade the services of the assistant librarian and 3 by enhancing their pay scale not less than rupees 22,000 plus 57,000 and get pay of rupees 10,300, which is being paid to the head assistant. Kama is required by amending the provision of Assam services, Assam service, we can make it ROK rule 2017 with a retrospective effect. That is from the date when the head assistants were paid the said pay scale and grade pay. Mr. I.S. Soikia, learned counsel for the petitioner submits that notice may be issued to the respondent authorities, then this matter may be taken with WPC number 1322 of 2025. As the issues raised in the said petition is same with the present petition. After having heard the submission of learned counsel for both the parties, I have carefully gone to the petition to the present record. And also correct the order of this court dated 10/3/2025 in WPC number 13/2025. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number so and so, as Mr. Troville appears and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Speak upon rest of the respondent, that is respondent number 3 be taken by the ATN observation process.
My lord, my friend will appear for 3, my lord.
Madam, you are appearing from
Finance.
appearing for respondent number 3. Okay. Since all the respondents are represented by the standing councils, no formal notice is required to be issued. However, extra requisite copy of the petition be furnished to them during the course of the day. Rest is the matter after 4 weeks. And take this matter along with WPC number 122 of 2025.
Obliged. May it please your lordship. My lord, in this matter, an office memorandum at my lord is
Professional appointment.
my lord. Regarding corporation appointment, my lord, that is under challenge. In fact, my lord, there is a series of cases pending where my lord affidavits are already exchanged. Those cases are fixed on 18th of March. So your lordship may tag this matter along with the other matters, my lord. One of the writ petition being 5067 of 2024.
WPC number
5067
2024.
24. And that series is fixed on 18th of March. In fact, your lordship has held that that particular my lord, memorandum cannot take retrospective effect, but that is also being considered because in the case your lordship passed my lord the order, there my lord the OM was not under challenge. Now the OM itself is under challenge in those series. My lord.
Or Mr. M.K.
Lordship, I have a small submission, Your Lordship. Lordship, the matter dates back to this 1998.
1998
and 2004. So clubbing both, it has been filed, Your Lordship, to petitioners. And in fact, that page 28 of the read petition.
Yes.
If the application of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application will require no further consideration and must be understood have spent force. So 1998, the purpose of the scheme, it do not meet perhaps.
That is
after 27 years. So
that is the issue, my
I'll-
lord,
I'll
pending
leave to your
before in
lordship.
the other cases. My lord. That is one of the issues.
Other issues, that is near to 2017.
No, in
Here-
there are cases of 1997 also pending.
Perhaps went by mistake, but
By mistake?
Okay, first decide the main issue by
Yes.
the. Or Mr. M.K. Sodore, learned senior counsel assisted by Mr. N. Sharma, learned counsel for the petitioner, and Mr. Devi for respondent number.
respondent number. One, two, 1, 2, and 9 euros.
1, 2, and 9.
Yes.
And Madam, you for
4, 7, and 8.
4, 7, and 8.
She will have 6, 7, 8. Only 3, bro.
She
She will be her by her.
3, 4, 7, and 8.
3, 4, 7, and 8. And 1 and 2,
1 and 2 by me.
you.
Yes, bro. 1, 2, and 9.
5 and 6. Mr. Sharma for respondent number 5 and 6. This petition under Article 226 of the Constitution of India, the petitioners have rightful is in direction to the respondent number case.
OM is dated 18 September 2024. This number to demand is 48.
To place their proposal for compassionate appointment before the SLCS struck DLCS for recommendation for appointment on compassionate law. Mr. Sharma, learned senior counsel for the petitioner, submits that the father of the petitioner, number 1, died on 26/9/1998, and the father of petitioner number 2 died on 30/12/2004, while died in harness while working as head teacher in Milon Primary School and subject teacher in Batmoria High School, SS School of Dhemali District. After the demise of their fathers, the petitioners have filed application before the respondent authorities for being appointed on compassionate ground. But the prayer was rejected by the respondent authorities, citing the office memorandum dated 18/9/2024. Mr. Chaudhary further submits that the said office memorandum is being challenged in WBC number 5067 of 2024.
And the series of cases.
State
And a
on
series one.
18/3/2023.
A series of cases.
And in series of cases. WBC number so and so and in series of cases. And the matters are being fixed on 18/3/2023. And as such, this matter also be taken with the aforementioned petition being 5067 of 2024. So there is some notice.
Your Worship, may issue notice.
The submission. However, at this stage, notice we issued to the respondent authorities. Returnable. When after 4 weeks.
Well, let it be tagged on that date, my lord. In the meantime, we'll take
Okay,
18th.
returnable on 18/3/2023. However, no formal notice is required to be issued as all the respondents are represented by their MDs council, by their standing council. Furnish extra requisite copy of the petition to the respective standing council during the course of the day. Is the matter on 18/3/2023 along with WBC.
God bless.
May I please, your lordship? Lordship, by this application, my lord, I am challenging my termination, my lord. What happened, my lord? The petitioner was working as an assistant professor in the Institute of Science and Technology at Jorhat, GIST, my lord, in the Department of Science and Computer Science, and Information Technology. Whatever, my lord, kindly turn to page 20 of Annexure 1, my lord. This is the advertisement plotted on 23/9/2021, my lord. This advertisement has been made by principal of the GIST, my lord. In this application, my lord, the applications were invited from the interested candidate to fill up the post of the computer science and information technology at the Institute of Science and Technology at Jorhat on purely temporary basis. My lord, this is the part-time faculty, my lord. Accordingly, my lord, I have applied, my lord. After that, my lord, and apply, my lord, and the principal has constituted panel for interview, my lord. That panel has been constituted on 29/9/2021. Thereafter, my lord, the examination was held on 1/10/2021. And then, my lord, the panel has submitted their result. After the result, my lord, I have joined in my service, my lord. That is my joining report, lordship. As per the instruction of the principal, my lord, I have joined before the HOD in reference to the advertisement dated 23/9/2020.
Whether they have filed their
Yeah, affidavit, lordship.
when
That is there.
have you filed affidavit?
This is my lord. I have
That is there, my lord.
filed my lord on
10. And my lord, what happened, my lord? Thereafter, my lord, I was working, and after joining in my post, my lord, kindly turn to page 22 is my joining. 21 is my joining, my lord. And my lord, 23 is the salary slip. This is the salary has been given from the treasury, my lord, government fund. And in the meantime, my lord, while I was appointed, my lord, the authority concerned did not issue any appointment letter to me, my lord. No appointment letter was given, but I was allowed and I have been paid regularly from the government head. And the Annexure 25, my representation, my lord, I have asked to the authority concerned, that is at page 25, my lord, to provide me the appointment letter regarding that particular appointment, my lord. But till that, my lord, nothing has been done. Thereafter, I was allowed to work. And later on, my lord, on 21/8/2023, my lord,
one experience certificate has been issued by the principal, my lord. That is at page 26, my lord. Mrs. Devika Deka has been rendering her service as assistant professor part-time basis in the Department of CS and IT at Jorhat Institute of Science and Technology, Jorhat 10, since 2/11/2021 till date. She is found to be hardworking, sincere, and regular in her duties. And thereafter, my lord, what happened, my lord? The government has taken a decision to terminate all the part-time employee working in the colleges, engineering colleges, and to re-engage after execution of a memorandum of agreement, my lord. That letter, that direction has been made at page 27, my lord, Annexure 6, 8/2/2024, my lord. In continuation of the letter under reference 1 above, you are hereby directed to consider one committee to verify the original documents regarding the eligibility criteria as per the AICTE UGC norms of the part-time faculty engaged from your end by constituting a committee if the original documents of the part-time faculties were not verified earlier by the screening or selection committee. And accordingly, my lord, the college has constituted a committee, my lord. Lordship will finding the committee report, my lord, at page 28, Annexure 7, my lord. My name is at serial number 9, my lord. Mrs. Devika Deka, Department of Subject IT, Computer Science and IT. I have the norms, my lord. That is at column 3. And accordingly, my lord, some persons, after verification, my lord, some assistant professor were found ineligible, my lord, and accordingly, they were terminated, my lord. I have not been terminated. Thereafter, my lord, turn to Annexure 8, my lord, page 29, my lord. In this letter, has been issued by the government of secretary to the government of Assam, my lord, Higher Education Department. By this letter, my lord, it is said that the part-time faculties may be allowed to execute a MOU, memorandum of understanding, my lord, between the parties, my lord. And this letter is said that with reference to the subject cited above, I am directed to inform that the government of Assam Higher Education Technical Department, in the interest of the interrupted academic activities, is pleased to allow extension of the term of the engagement of GAS part-time faculty at GIS, Jorhat, who are otherwise eligible. I am eligible, my lord, as per the findings at page 28, my lord. As per the committee report, I am eligible, my lord. Eligible for lordship.
Page number?
As per the page number earlier, Annexure, my lord, Annexure 7. That is the report submitted by the committee constituted for verification, my lord.
Yes, sir.
My name is page serial number 9. I am eligible, my lord. I have been found eligible. And by this letter, my lord, all colleges, the gist was directed to execute an MOU between the part-time. And prior to that, my lord, prior to execution of the MOU, my lord, the part-time faculties were terminated. That is at page 30, Annexure 9, my lord. That is important, my lord. This office order has been issued by the principal Jorhat GIST, my lord. This is our appointing authority, my lord. The following part-time assistant professors GIST are hereby disengaged from 31st of July 2024. As per the DTE file number so-and-so, dated so-and-so, they may be re-engaged after having executed the proper memorandum of agreement to provide by the office of the DT in due course of time. And my lord, my name is page serial number 9, my lord. All the similar situated assistant professors were terminated. And these are the persons who are eligible. They has been declared eligible by the screening committee, my lord. After issuance of this termination, my lord, my first part of engagement has been gone out, my lord. That part has been gone out. Thereafter, my lord, as per the Annexure 10, my lord, director directed the principal to execute the MOU, my lord. This is the letter at page 31. And MOU has been executed. Lordship will find that MOU at Annexure 11, page 32. This memorandum of agreement has been executed on 5th day of September 2024, my lord. This has been duly signed by the petitioner, present petitioner, and the principal of the GIST, my lord. In there, my lord, 3 columns. three clauses are very important, my lord. Number 3, the GAS part-time assistant professor in the engineering colleges or GAS part-time lecturer in the polytechnic does not have any right for regularization, have no any right for regularization against the sanctioned vacant posts, as these posts are to be filled up through appropriate selection process and to be appointed by the government on a regular basis. Number 4, the government will have no liability for continuity of engagement of the GAS part-time assistant professor in engineering colleges, lecturer in polytechnic. The engagement as GAS part-time assistant professor in engineering college or GAS part-time lecturer in polytechnics may be terminated at any time without any prior notice and assigning any reason thereto in case performance of the GAS part-time assistant professor in engineering college, lecturer, polytechnics is found unsatisfactory or regular faculty is appointed against the sanctioned post, whichever is applicable. Nothing has been done, nothing has been happened, my lord. Thereafter, my lord, what happened, my lord, the director of the higher education technical has submitted the total data who are occupying the sanctioned post as the assistant professor in the engineering college and lecturer in the polytechnic. That data is submitted by the letter dated 26/7/2024 before the government, my lord. Lordship will find at page 36, my lord. This letter has been supported by the 4 annexures, my lord. First annexure, table number 1, my lord. This is the part-time faculty of engineering colleges engaged in the institute under the DTE. The total strength of that such kind of assistant professors is 165 in respect of the all government engineering colleges in Assam. In Jorhat Institute of Science and Technology, 24. That is at serial number 6, my lord. These are the engineering colleges, government engineering colleges in the state. And accordingly, next page is for a lecturer in the polytechnics. That is altogether 257. They are working. And next are the part-time senior instructor in the engineering colleges. Total is 6, my lord. And then part-time senior instructor in polytechnic, that is total 23. Altogether, it is the figure is 451, my lord. In this 4 table, my lord, total figure is 451, my lord. Instructor, lecturer, senior instructor, and assistant professor. And in the meantime, my lord, the honorable cabinet of the government of Assam has taken a decision, my lord, cabinet decision. My lord, annexure 42, annexure 13, page 42, my lord. This is the portal copy of the honorable chief minister of Assam, my lord. And original minus I have annexed at annexure 14 at page 43, my lord. My lord, kindly see the portal copy, my lord, first for the time being, my lord. Cabinet has accorded approval to the proposal of re-engagement of 451 part-time faculty against the existing vacant posts in Gov Engineering College and Polytechnic in Assam under Rule 3F. 451, that data has been already submitted by the director to the government. On the basis of that, my lord, 451. This figure is 451 come from that particular letter, my lord. Annex of 12. And the decision will ensure uninterrupted academic classes and other related activities on every branch in government engineering colleges and polytechnics. And my lord, turn to next page, my lord. This is the minutes. The extract of the minutes of the cabinet meeting held on 24/9/2024 at 4 p.m. in the cabinet room of the chief minister's office at Lokaseva Bhavan, J Block, Dispur, Guwahati, my lord. The subject is that the re-engagement of part-time faculty proposed to be renamed as contractual faculty against the existing vacant posts in the government engineering colleges and polytechnics in Assam. The decision is that, my lord, the cabinet rejected the proposal for the change of nomenclature of the part-time faculty and GAS faculty engaged in various polytechnic colleges and government engineering colleges across Assam as contractual faculty. Instead, the cabinet approved engagement of these. This means 451, my lord. Faculties on ad hoc basis against the sanctioned post in accordance with the principles outlined in Regulation 3F as per the extant rules as applicable for the appointment in the government engineering colleges and polytechnic, my lord. By this notification, by this decision, my lord, cabinet, the state government cabinet, the councils of minister of the government of Assam, my lord, has decided to convert this post. Their part-time faculties should be converted to the TF faculties, my lord, on ad hoc basis, my lord. This is also temporary post, my lord. TF and my lord, the nature of the part-time faculty is the same, my lord. And my lord, after that, my lord, the government has issued a letter, my lord. The additional secretary has issued a letter to the director to disengage all the persons who were working in the engineering colleges on 29 October 2024. First, by this letter, my lord, it was asked to disengage the persons, the assistant professors who were appointed by the principal, not by the director of technical education, my lord. And later on, my lord, by in the year of later on, my lord, the government has directed the director to disengage all the persons who were appointed by the DT and principals, my lord. And thereafter, my lord, what happened? Kindly turn to page 46, my lord. This notice has been issued by the principal of the GIS, my lord. By this notification, my lord, we were all the 9 assistant professor working in the various department in the GIS were terminated, my lord. This is my second termination, my lord. That is at page 46, annex 17, my lord. My name at last, my lord, I, Miss Devika Deka, part-time assistant professor, CS and IT department. Top of the line, the bottom of the line, my lord. And this is my second termination, my lord. And later on, my lord, one appointment notification has been made. That is, lordship will find at page 47, annex 18, my lord. This has been issued on 22/1/2025, my lord. And here, my lord, it is clearly stated that subject to the discharge without assigning any reason thereof, the following persons are appointed temporarily as assistant professor in the Government Engineering College of Assam, and as per the regulation TF of the APSC limitation of function regulation 1951 and personal department when related to appointment under the regulation TF APSC remuneration so and so 1,000 remuneration of rupees 1,000 per hour subject to the limit of rupees 72,000 per month, considering their engagement for a period of 4 months as per the aforementioned personnel department OM or till the time of replacement regular employees, whichever is earlier and posted in the college and institution shown against is the effect. And later on, and in this appointment letter, my lord, my name at serial number 69, my lord. That is at page 50. And thereafter, my lord, I have joined in my respective post, my lord. And after joining, my lord, I was regularly attending the classes, and I have been also allotted so many work by the principal and the department. And in the meantime, my lord, without any notification, without any reason, my lord, my termination has been issued. That is, lordship will find at page 55, annex 22. Last one, my lord. In this notification, it is said by this notification, my lord, I have been terminated from service on 16/2/2025, my lord. It is a blanket. Nothing has been explained why I have been disengaged. And later, immediately, my lord, I approach your lordships. After that, my lord, they were supposed to bring the instruction, my lord. And on the instruction, my lord, in response to that instruction, my lord, they have filed this affidavit, my lord. In this affidavit, my lord, they have stated that paragraph 9, my lord. Paragraph 9, my lord. It's serial number 66, lordship. Page 66, huh? Page 66, lordship. The deponent begs to state that thereafter the deponent asks the principal of GIS Jorhat, to submit relevant information and documents with respect to the engagement appointment of the petitioner at GIS, Jorhat. As per the said information report submitted by the principal GIS by letter bearing number so and so, dated so and so, no initial engagement letter was available at his office in respect of the petitioner, and no formal proposal for regularization of the said post was sent. No regularization, my lord. Only one thing is that no, it is not available with the office, my lord. Whereas, my lord, I was working till that, till my second termination, my lord. And paragraph 10, my lord, this is the important, my lord. This is the issue on paragraph 10, my lord. This is the issue for which, my lord, I have been terminated, my lord. This is not covered by the law, my lord. The deponent begs to state that since the petitioner could not produce any initial engagement, I have not asked to produce anything, my lord. Nothing has been initiated. Initial engagement letter as part-time guest faculty in GIST issued by the principal, GIST, or any other higher authority. Therefore, the petitioner does not come under the zone of consideration for appointment as per regular TF APSC in accordance with the cabinet decision dated 24/9/2024. This is only the issue that I have no initial appointment letter. That is 21 letter, my lord. That 21 I have been terminated first. Later on, MOA has been executed. My fresh engagement, re-engagement has been done. That has also been disengaged, terminated. After that termination, my lord, I have been given the TF appointment. At present, my lord, in the state, my lord, there is no any ad hoc rule, my lord. One rule was there, my lord, 86 rule, that has been already repealed, my lord. And the TF appointment are generally made by not office memorandum, my lord. In office memorandum, my lord, there are so many office memorandum has been issued, my lord, by the government time to time to make the TF appointment, my lord. That is the 2001 office memorandum, my lord. By this memorandum, my lord, TF appointment should be made directly. The first line. May I read the relevant portion, my lord? May I read the relevant portion? Relevant portion is the serial number 2 first. 2 and 3, my lord. I'm reading, my lord. In every case of ad hoc appointment, the TF appointment is always ad hoc, my lord. As per the provisions of regulation TF, my lord. In every case of ad hoc appointment, it shall be based on the departmental selection process involving issue of a proper advertisement, giving reasonable time and inviting candidature from the eligibility candidates. The case of the candidate for ad hoc appointment shall not be considered merely on the basis of an application submitted by him without any proper advertisement. In the advertisement, it must be specifically mentioned that the appointment to be made in purely on ad hoc basis, and to become eligible for regular appointment, a candidate must qualify himself in the regular recruitment test as and when held. Number 3, by this serial number 2, my lord, it is clearly stated that the ad hoc appointment under the provisions of TF, in the top, it is written, my lord. First, my lord, selection committee may be constituted, advertisement should be made, selection process should be initiated, and select the eligible person and appoint them in ad hoc process. This is the principle for TF appointment, my lord. But in the present case, my lord, this has not been adopted. Why, my lord? This appointment has been made on the basis of the cabinet decision dated 24/9/2024. Cabinet has decided to re-engage the 451 candidate persons who were occupied the post of the assistant professor and lecturer in polytechnic and engineering colleges. They will be converted to the TF. Therefore, my lord, this process has not been adopted, my lord. This has not been adopted, and my lord, appointment letter has been issued on the basis of that particular person, because That cabinet decision is very much specific. This cabinet decision very much specific that these persons, this candidate, this means us, my lord, who were working prior at the time of the taking decision, my lord, who were working in the colleges and engineering colleges and polytechnics. This decision has cabinet decision in respect of them. This is, my lord, repeatedly kindly against see, my lord. Against see, my lord, for the time being, my lord. At page 43, my lord, this is the decision abstract. Yes. Second part, my lord. Instead, the cabinet approve in the third line, my lord. Instead, the cabinet approve engage of these faculties, my lord. This means those who are working in the college at that time, my lord, on ad hoc basis against the sanction post. We were all appointed against the sanction vacant post, in accordance with the principles outlined in the regulation TF as per the extant rules as applicable for the appointment in the government engineering college and polytechnic in Assam. My lord, there is only the office memorandum. Time to time, my lord, office memorandum has been up to date, my lord. Second one, good. 2015, also, my lord, another memorandum, office memorandum in respect of TF has been issued.
No, whether the earlier notification of earlier OM was superseded. Not superseded.
No, not super. In respect of 2001, second notification has been issued, my lord. 2015, on 16 March 2015. It is clearly written, any such proposal as cleared by the state cabinet for appointment under the regulation TF shall have to pass through all the steps as laid down in the guidelines of OM number so and so dated 29 October 2001. Read with the APB so and so 3 June at 2001, copy and goes. That 2001 I have already been given. And this is also, and my lord, this is same, my lord, some modification has been done, my lord, by this to 2015. My point is not that, my lord. My point is that, my lord, enter appointment, TF appointment has been made only on the basis of that particular cabinet decision. And in the affidavit, my lord, they have stated that I have no initial appointment letter. I have no initial appointment letter. Kindly turn paragraph 10 of their affidavit, my lord. It is said that as part-time guest faculty in GIS issued by the principal GIS or any other higher authority, therefore the petitioner does not come under the zone of consideration for appointment as per regular TA of APSC in accordance with the cabinet decision. My lord, where they have got this? Which rule, my lord? Nothing has been disclosed in this paragraph, my lord. Simply said, I am not fall under the zone of consideration. Whose consideration, my lord? Whose decision, my lord? My lord, in this regard, my lord, I like to submit a Supreme Court decision, my lord. In this regard, Supreme Court is very much clear, my lord. Very much clear. 2000. Right? Lloyd Electric and Engineering Limited, State of Himachal Pradesh, and others, my lord. The Supreme Court kindly turn to paragraph 10, my lord. Paragraph 10. I am reading, my lord. We do not think it is necessary to go into various contention raised by the parties in view of the undisputed factual position we have referred to above. The state government cannot speak in two voices. Once the cabinet take a policy decision to extend the each for 2004 industrial policy in the matter of CST concession to the eligible units beyond so and so and up to so and so, the notification dated so and so accordingly having been issued by the department concerned, this the Department of Industry thereafter, the excise and taxation department cannot take a different stand. What is given by the right hand cannot be taken by the left hand. The government shall speak only in one voice. It has only one policy. The departments are to implement the government policy and not their own policy, my lord. Department cannot take their own policy, my lord. Zone of consideration, their zone of consideration, they cannot take the decision, my lord. This is they have made the appointment as per the cabinet decision. Cabinet said these persons, 251, should be converted to the TF. They cannot verify anything, my lord. Since we were eligible, we were working at the time of the taking decision, my lord. When the 24/9/2024 decision has been taken by the cabinet, my lord, I'm reading more, my lord. More thing is there, my lord, in this paragraph, my lord. What is given by the right hand cannot be taken by the. It is only the one policy. The department are to implement the government policy and not to their own policy, my lord. I mean, again reading, my lord. The departments are to implement the government policy and not their own policy, my lord. They cannot take their zone of consideration, my lord. As per the paragraph 10, my lord. Since the cabinet has taken decision to convert them to the TF, thereafter, my lord, they cannot take decision. Yes, they can take decision if they have submitted the proposal to the department, cabinet for TF appointment and follow as per the office memorandum 2021, my lord. If that process has been initiated, then they can take the decision. But here, my lord, this is alter, my lord. Here, my lord, cabinet has taken decision. Cabinet decision is always the policy decision, my lord. And in this regard, my lord, they cannot take their own decision, my lord. And once the council of the minister has taken a decision to extend so-and-so industrial policy and extend tax concession beyond so-and-so, merely because the excise and taxation department took some time to issue the notification, it cannot be held that the eligible unit are not entitled to concession till the department issued the notification. That consideration, that consider zone of consideration, paragraph 10. It does not mean that I have not. And my lord, why I have not the initial appointment letter, this is not my guilty, my lord. I am coming to that point, my lord, by the judgment, my lord, findings of the honorable court. Taxation department eligible, not entitled to concession. It has to be noted that the finance department of the state government had concurred with the proposal of the Department of Industries to extend the tax concession beyond so-and-so till so-and-so, and the Council of Ministers had accordingly taken a decision also. No doubt the statutory notification issued by the Excise and Taxation Department under section so-and-so of the Act on so-and-so has stated that the eligible unit will be entitled to the concession with immediate effect, merely because such an expression has been used. It cannot be held that the state government can levy the tax against its own policy. The state government is bound by the policy decision taken by the Council of Ministers and duly notified by the department concerned so-and-so, so-and-so, so-and-so. They cannot do anything, my lord. They cannot take any view. And my lord, they have taken zone of consideration. That zone of consideration cannot be considered. Has no any existence as per this particular paragraph of the Honorable Supreme Court, my lord. My lord, it is always considered that the
No, the fact remains that you failed to produce your initial engagement letter.
Initial engagement letter, my lord. That initial engagement letter I have not been given by the department. In this regard, my lord, I have submitted an RTI before the principal. What principal say, my lord? My lord, my RTI, this is my application, my lord. First page, D and E, my lord. D and E, and last page is the answer, my lord. Last page is the E, my lord. Last page, and point number 4E. Copy enclosed appointment letters of Ms. Deepika Deka is not available in this office. Number 4F, no justification is found. Most probably the office forgot to provide it. Most probably office forgot to provide it. And in this regard, my lord, I have already submitted the representation prior to my first disengagement, my lord. After that disengagement, my lord, they should not re-engage me again, my lord, by executing the MOA, my lord. After the
So do you have any other document to show that during that period you have drawn the salary?
yes,
Page number?
yes, some I have already been annexed, and another is this is my bank statement, my lord. Yes, no, my turn. My lord, I have highlighted the dates when my lord treasury has deposited the salary, monthly salary of 72,000.
This is the certificate issued by Treasury.
This is the bank statement directly deposited by the bank. There is the treasury is written there, my lord. This is a state bank statement, my lord. My lord, I have highlighted the all data in months wise.
First, you have been engaged in the year 2021.
Yes, my lord.
So where is that statement? This is of 24.
That is and I have annexed, my lord.
Where?
That is that annex T, page 23, annex T, my lord. At that time, my lord, my salary was less, my lord. This is the for month of November 2021. This is the month of December 2021.
In which month you have joined?
To 11/2021. That is at page 21. And then, my lord, page 25, that has been submitted on 1/2/2024, asking for the request for issue of an appointment letter, my lord, to the principal, my lord. It has been duly accepted, acknowledged. Next page, my lord, that's 25. Thereafter, my lord, we were verified. That is verification report. In the verification, I was found eligible. I have the norms, my lord. And thereafter, my lord, I have been terminated on 16/7/2024, July. In the month of February, I asked for the appointment letter. In the month of July, my lord, I have been terminated. That means, my lord, my first part has been gone. Another, my lord, this is not provided me. Provided me. This is not my duty. I cannot take my own appointment letter, my lord. This should be provided by the department, my lord. If it is not provided by the department, without my guilty, my lord. In this regard, my lord, the division bench of Honorable Bombay High Court says, due to the fault on part of the employer, employees should not be allowed to harass, my lord. এখন দিব না। I have asked earlier, my lord, not provided. And in the RTA, it has been said that the office may forgot to provide it. In the paragraph 2, my lord, the division bench of the Maharashtra High Court, my lord. Paragraph 2, my lord. The employee cannot be allowed to suffer because of inaction on the part of the employer for no fault of the employee, my lord. Settled position of law, my lord. My lord, here, my lord, in the respect of the appointment letter, my lord, that appointment letter for the first instance, my lord, first appointment, and that appointment has terminated. I have been disengaged, my lord, by Annexure 9, my lord, at page 30, 16/7/2024. This is my, in respect of that initial appointment letter, I have been terminated. This is my past service, my lord. And later on, my lord, MOA has been executed.
Yes, what is your stand?
Kindly have para 8, my lord, 8 and 9 of my affidavit, my lord, 65. Why, why the document verification was necessary, my lord? Necessary before, my lord, engaging the petitioner in 3F, my lord. Para 8, my lord. The department makes it that earlier an inquiry was conducted by Sri So-and-so IAS, the then additional chief secretary to the government of Assam Higher Education Department, with respect to the appointment of part-time lecturers, part-time assistant professors by the Department of Technical Education, principals of Assam Engineering Colleges and Polytechnics from time to time. During the process of the inquiry, the deponent and the principals of engineering colleges and polytechnics were called for hearing, along with instructions to submit relevant documents of the candidates who were engaged as part-time faculty. The report of the said inquiry was submitted by so-and-so, the then additional chief secretary to the government of Assam Higher Education Department on so-and-so, and as per the said report, it was found that while engaging the part-time faculties, no prior approval was sought for from the higher authority, and no proper procedure was followed in finalizing the selection of candidates by the respective principals of the institution. Moreover, as per the said report, even some candidates were engaged who did not fulfill the AICTE norms. This is the reason why document verification was necessary.
Is it your case that the present petitioner does not fulfill the
No.
AICTE
As per
norms?
no, as per the documents, what has been submitted by my friend Malad, this in that the petitioner is eligible. Now, Malad, at the time of Malad, of verification, principal of that particular institute was called for to submit documents regarding engagement of the petitioner, Malad. Then kindly have annexure 1, Malad, page 69. Page 69. It says that, my lord, answer to point number 1, my lord, no initial engagement letter is available in this office in respect of the petitioner. Now, my lord, the question is if, my lord, what had happened, my lord, earlier, the principles
The
of.
question is whether she is responsible for the same.
Sorry, my lord.
Whether she is responsible for the same due to non-availability of appointment letter.
My lord, what had happened earlier, my lord, principals directly appointed, my lord, the procedure was to appoint regular faculty through APSC, my lord. In absence of regular appointment of regular faculty, my lord, the principals of institute, they personally either call for direct interview or advertisement, my lord, and engaged candidates, my lord. Here in this case, my lord, admittedly, there was an advertisement, my lord, as per page 20 of the petition. Even if we assume that, my lord, that the principal of that institute did not provide any appointment letter, but the question is on what basis the petitioner has joined his service, and if there is an advertisement, then there must have been an.
No, you have utilized her service and you have paid salary also.
That is okay, my lord.
Then
there is no dispute regarding paid of salary.
Then
dispute is, my lord, whether the petitioner
how can you appoint the petitioner without any appointment letter or engagement letter?
My lord, earlier engagement earlier engagement, even if that is if the earlier engagement is illegal, if I may say so, my lord, if earlier engagement was illegal, then that engagement will not create a right in favor of the petitioner to be adjusted.
How her earlier engagement was illegal? On what basis he was submitting it?
No, my lord, I am just
Where,
submitting.
where is your averment in the?
That's why, my lord,
affidavit?
that's why, my lord, I said that if I may say so, my lord, because what my submission would be, my lord, admittedly there was an advertisement as per page 20. If there was an advertisement, there must have been a list of selected candidates. If the petitioner doesn't have the appointment letter, at least the petitioner should produce the documents of selected where he's
No. She has not been issued the appointment letter, engagement letter. Who is responsible for the same? The person who has utilized her service?
Utilize his service, my lord, at the time of.
Then you have paid salary also, it is also not disputed.
Still salary, the petitioner is getting the salary. My lord,
We are staying the order.
sorry, my lord.
We are staying the order.
My submission would be, my lord, that the initial appointment letter, my lord, initial appointment letter, if that is not available, if, my lord, if the case is that the petitioner is
Next item.
is known to the, my lord, principal, that will not create a right in favor of the petitioner, my lord.
Oblige, your lordship. Oblige, your lordship.
May it please, my lord. A petitioner was appointed before 2012, my lord. Hereafter, they have obtained B.Ed degree, my lord. There is a notification, page 43. If my lord appointed before 2012 and B.Ed degree from NCT, there is one advance increment is have to, my lord, acquiring, my lord. And there is, my lord, page 43, my lord, this notification. Subject regarding advance increment for acquiring B.Ed degree. With reference to the subject cited above, I am directed to inform you that Honorable High Court order dated so and so in WPC number 6241/2015 has quashed the government notification dated 22/10/2014. Hence, all assistant teachers are eligible to get one advance increment for acquiring B.Ed degree provided. Number one, he public C has joined before 3/7/2012 and obtained B.Ed degree from UGC recognized university and NCT approved B.Ed college, my lord. My lord, similar, my lord, situated persons, my lord, case was, my lord, disposed of, page 50, my lord. In same line, my lord, your lordship may dispose of, my lord.
Page number?
50, my lord. Here is the order of this owner.
Yes, Mr. Rava.
My lord, at this stage, notice may go, my lord.
My lord.
Because the petitioners are from different schools, my lord.
Yes, my lord. In this case also,
Maybe,
my
but whether this order at 14/8/2024 over the case of the petitioner.
petitioner's appointment order was pasted from page 18, my lord. Representation is
Maybe, my lord, representations may be considered.
Yes, my lord. In this order also, my lord, same press representation is to submit it, and that's after verification. They will mail it.
So similar order.
Yes.
Okay.
Next case, next two cases also same, my lord. Next 46 and 47. Simple.
Okay. We'll pass similar order.
Obliged.
My pleasure, lordship. From the morning hours, my lord, instruction was sought for to be placed before the court at 2 o'clock, my lord. What is the instruction?
In addition to that, that may be This updated instruction will be read along with them.
It is, sir. আমার against over there.
So in terms of the honorable courts, in compliance of the honorable court's order, this termination was carried out. And lordship thereafter, the second also, initially the process, the hearing process was not completed, therefore she was terminated, her case was withdrawn in July. Then subsequently, that was revoked and the due procedure of followed. This is the updated.
Temporary থাকা জোরপূর্বক order
Yes. Yeah, start man.
This, you have written the provincialization of order, but what is the ground? What is the ground?
It is in terms of the honorable court's order, lordship. The honorable court's order is in the petition, it is annexed, lordship.
It never directed, my lord. Page 51.
Page 51.
Page number?
Page number 51, paragraph 12, my lord. If your lordship permit me, I'll just read out, my lord. Accordingly, irrespective of the aspect, 4 posts would be available for provincialization of the service assistant professor in the Department of SMEs in the Hardy College, the amended Act 2070, whether still 3 posts would be applicable, the respondent being Director of Higher Education Assam to pass consequential order for provincialization of the petitioner in terms of Act within 4 weeks from the date of the receipt of the certified copy. In doing so, the director is required to pass further order which may have adverse consequences as regard the assistant professors who may have been provincialized in the meantime. Director may do so following the due procedure of law, giving opportunity of notice to the persons who may be affected. At the same time, if 4 posts are available, there are 4 assistant professors in the subject of SMEs as per the teaching and non-teaching staff pattern as provided by the principal. We even see no reason for any adverse order to be required against anybody else provincializing service of the petitioner. It has been clarified. No adverse order has to be given to me. Now, Lordship will see one thing. Page 45 is my provincialization order. Because that time, my lord, I was the only one having NAT and SLAC. And he does not have the record qualification. That also I'm coming, my lord. Lordship, kindly have a look the page 45. Serial number 1, Lordship will see Assistant Professor SME so-and-so SAT number so-and-so 26 to 14. Yes, Lordship will see page 45, annex of 4, by virtue of which my service was provincialization. That was done, my lord, 20 June 2015. Then, my lord, it was to accommodate the private respondent number 10, my lord. It was temporarily withdrawn. Then, my lord, I filed a writ petition. That was, they have revoked it. That order, lordship will see. Immediately, I challenge that order, my lord. Page 55. Page 55, my lord, the order issued by memo number is hereby the service of a assistant professor of the Hatheli College, Lakhimpur was withdrawn and revoked. So my writ petition has become infectious, my lord. Next page, we have filed a writ petition, my lord, with a liberty, the present writ petition. Now, lordship will see one very interesting thing, my lord, as per the law laid down. Lordship will see page 10. I have given elaborate, my lord. Who got when, my lord?
Page number?
Page number 10, my lord. It starts from para 9, my lord, last paragraph. It will be convenient for your lordship, my lord. Last line, my lord. Respondent number 9 was appointed by governing body on 25/3/2003. She qualified TAT on 10 NAT on 10/11/14. Respondent number 10 was appointed by governing body on 2011-08. She qualified NAT before joining. As such, the service of provincialization authority to the third post by letter number. It is stated that the NAT select the petitioner service was provincialized by number so and so. So during that time, my lord, the serial number 3, lordship will see the book which she need to have at least minimum book to dear, na? Book to did, yeah. 647. What is the qualification? Lordship will see from my book, my lord, if your lordship is having page number 8 to 654 and 647. Seven years, my lord, simultaneously it was been continuous service has to be there than 6 years. And that time, my lord, she was only 5 and some months.
You were referring to page number?
Page number, my lord.
647.
Yes, my lord, 647, section 4. Section 4, your lordship will see at page 654.
This is of 2011 Act.
Yes, my lord, by virtue of which they got. Now we're coming to that, my lord. She was provincialized during that, my lord. That has been revealed, but she was appointed, my lord, to clarify, my lord. That time, lordship will see the section 4. The service of the employees of all the eligible venture school institutions, section 3 shall be deemed to have been provincialized the date of the coming into force of the act. They shall become a employee of the state with effect from date of that, the provincialization, the institution, the completed at least 7 years of service. Next page, my lord. Then, my lord, it was brought down by virtue of the amendment, sound the amendment to the amendment, it has been 6 years. Amendment to the what does it? Page core. And I have reproduced the amended part, my lord, page 21, be seen, my lord.
Page?
Page 22.
In the writ petition?
page 22 of my writ petition, my lord, Roman 3. Roman 3 said brought down to 6 years. Lordship has come across last line, man, last paragraph. Must have rendered at least 6 years of service, continuous service as on so and so from the date of joining concert Benser school so and so. And she doesn't have that much qualification, 5 years something.
Paragraph number?
Paragraph, Lordship will see page 22. Page 22, Roman 3.
Yes.
Of earlier, my lord, must have rendered at least 6 years of continuous service as on 17 from the date of joining of the concerned venture institution must be on 31/12/10 prior to that. And she doesn't have that 7 years nor 6 years. Her date of joining, Lordship will see 26/5/14 at page 10 or 2011-2008, my lord, date of joining. She does not have the qualification, 7 years. Similarly, the other respondent, my lord, she qualified her net, sorry, my lord. কেতিয়া কৰিছে? আমার বেলেগ টু 10 নম্বর টু কোট লেখা and respondent number 9, my lord, lordship kindly back to page 10 again, my lord. Pratibha Bora, Pranita Bora, she completed her net only on 10/11/2014, and whereas I have completed much earlier to her. And so for the impugn speaking order, my lord, misinterpretation, my lord, because they want to say it from contempt case, my lord, they withdrawn my appointment. So in view of that, lordship has seen the at page 51, the Honorable High Court never said to affect my law, page 51. No adverse order required to be else provincialization of service of the while considering her case, my lord, no one shall be disturbed, meaning thereby. But here, my lord, by speaking order, my service was disturbed. Oh, no. What mentioned speaking order? And nowhere, my lord, in the judgment also, my lord, I was a party, nor, my lord, they have mentioned the name of respondent number 10 anywhere, even including, my lord, impugn order, which are reflected at page 87. Page 87, my lord. And what comply of the order, my lord, Honorable Court never said, my lord, to disturb my service career. Wrong interpretation, my lord. They have apprised to the Honorable High Court, my lord, that the order has been complied with. As a result, my provincialization has been withdrawn without any basis reason, despite the fact that, my lord, she does not have qualification. So in view of that, my lord, lordship will stay the operation of the impugn order, my lord. It does not reflect, my lord, from where I got the power. And why, my lord, no cause and reason has been given, my lord, page 87, lordship will see. That is required to be stayed, my lord. Because, my lord, order is very much clear at page 51. Honorable High Court filed by the other writ petition. They are needed to be accommodated in the next post, but 4 number post available with the 4 assistant teacher in the subject of assembly non-teaching pattern is provided the principal. We may see no reason for any adverse order required to.
Mr. Porboya,
Lordship,
today he has produced another order.
No, this is the in terms of the instruction. Honorable Court had directed to produce the instruction. As to why two times the petitioner's provincialization was withdrawn initially first, then revoked, then why again withdrawn on in basis of the same honorable court's order. So the reason was that initial withdrawal was done without following due process of law. The hearing was not conducted, so it was revoked. Then subsequently, in the lordship, the second instruction I have produced, the subsequently hearing was carried out. Then after hearing was carried, in compliance of the honorable court's order, we have withdrawn down.
Honorable Court never said, my lord, page 51, again, lordship, kindly see.
No, Mr. Borboya,
Lordship,
you see, unless you challenge the subsequent order,
Yeah.
then I don't think you will be entitled to get any relief.
so lordship,
You first you go through these two letters.
let
What is Friday?
let me get copy, my lord, lordship fix the matter on Friday.
Friday is
Oh,
holiday.
Friday, Monday.
Friday is
no,
holiday. Next day, next day,
Monday.
Wednesday.
Lordship is sitting, my lord.
Pardon?
Lordship are sitting in that same bench because lordship has heard the matter, my lord.
No, that's all right. We'll keep the matter as parted.
Lordship.
Actually, this is not a new order. This is the instruction that we have produced. The order, the challenge is here. That is not the new order. This is the instruction in terms of the honorable court's order.
Let him go through the
Yes,
this
yes.
instruction.
Lordship keep the matter as a part heard, lordship fix the matter as your lordship's convenient.
Otherwise, lordship, regarding the pay, whether lordship, the order has been passed in terms of the honorable court's order.
That I am brought, my lord, page 51 never said.
Lordship, may I?
Let him
Page
submit.
51, lordship, in page 51, it is clearly stated that any whosoever may be lordship affected. Paragraph 12. Once again, may I leave lordship? Paragraph 12.
Page number?
Page 51.
Yes.
May I read? Paragraph 12. lordship. Accordingly, irrespective of the aspect whether 4 posts would be available for provincializing the service of the assistant professors in the Department of Assamese in Harhi College after amendment of the Act 2017, or whether still 3 posts would be available, the respondents being the Director of the Higher Education Assam, to pass a consequential order for provincialization of the petitioner in terms of the Act of 2017 within a period of 4 weeks from the date of receipt of the aforesaid copy of the order. So 2000, in terms of 2017, directed to be appointed to the petitioner. Lordship. If in doing so, the director is required to pass any further order which may have adverse consequence as regards any other assistant professor who may have been provincialized in the meantime, the director may do so by following due procedure of law and giving appropriate notice to such persons who may be affected.
But
so this is clear. Then subsequently,
let him read complete, my lord.
yes, subsequently, I'm going. But at the same time, if 4 posts are available and there are 4 assistant professors in the subject of Assamese, as per the teaching and non-teaching staff pattern as provided by the principal, we even see no reason or any adverse order to be required against anybody else for provincializing the service of the petitioner. So petitioner is need to be in the earlier decision, the petitioner was directed to be lordship provincialized. So in terms of that, we have provincialized. We have called the hearing lordship. So let him go through the instruction.
Lordship will see, my lord, for any adverse order required against anybody else, provisioning service of the petitioner. Last 2 lines, my lord.
Whether lordship,
we see no reason.
Mr. Wilder,
lordship.
Whether the present petitioner was a party in the earlier proceeding?
No. What no? I have annexed the order in case of.
No, not.
No, I was not made.
Yes, because she was not made a party by the petitioner. So lordship, whether lordship
So
can
without hearing the other
yes,
side,
that is correct. This order was passed. Lordship. It is the petitioner did not made any party. So whether lordship can pass any interim order or if I
Lordship has to pass. My
submission,
service
lordship,
gone, my lord.
in my humble submission, it would amount to reviewing the order.
pardon?
If lordship any order is passed, I think lordship in my humble submission, it would be reviewing the previous order. Amounts to be or appeal. Because clear direction was there.
Mr. Borgoya, you studied the matter?
Yes, my lord, I have gone through, my lord, even lordship permit me to, I'll just go through the instruction which have been received, my lord. Over and above laws, page 51, again, my lord, last two lines. Honorable court was
No,
confirmed, my lord,
if 4 posts are available,
if 4 posts are available.
how many posts are available there?
4 is
4.
4,
Then why adverse order was passed?
my lord, that's what.
No, Lordship, but in the previous line. In the
They
previous-
suppress, my lord, serial number 3.
In the previous line, Lordship, or paragraph 12, it is clearly stated.
No, no. The previous line and the
Last
line
line, lordship will see, even we see no reason to adverse order to be required against anybody else, provincialization service of the petitioner, meaning thereby during service, provincialization service of the petitioner, no adverse would be given to any person.
Mr. Borgoya, you do one thing.
Lordship,
You study the
lordship,
instruction received
lordship,
by
lordship,
him today. And we'll finally hear the matter.
lordship,
We
lordship.
will not pass the interim order.
Lordship,
Finally,
lordship.
we'll dispose of the petition.
Lord.
You have filed your affidavit?
My lord, I am not getting any salary, anything, my lord. Some interim order has to be given, my lord. Not giving effect to the private respondent, my lord. That much be given, my lord.
Interim
If your
order-
lordship
order-
is not
No, no,
given to
no.
me, my lord, I am not
Mr.
worried that.
Mr.
At least
Tawilder,
somebody has to be
Lordship,
protected, my lord.
You see,
Lordship.
if 4 posts are available,
Hmm.
then why this adverse order was passed against the present petitioner?
No, Lordship, in the earlier lines, it is written that the.
Maybe that may be there,
Yes, Lord.
but the said line is subsequently clarified.
Last two lines.
Yes, right. Right. Lordship.
In the last line, it has been clarified.
Yes, I'll obtain instruction also on the next day. I'll claim. And I file affidavit also.
My lord, this is buying time, my lord. I am lady, my lord. My job has been snatched away after giving bread. Lordship has seen page 45, my provincialization. In the meantime, my lord, no effect should
No,
be
no,
given to others.
Mr. Borgoya will finally dispose of the matter.
That is true, my lord. Lordship will dispose of matter. That is true, my lord. But here in the case, my lord,
No,
until and unless
if
some
we
interim,
pass any interim order today,
or lordship fix
I
the
don't
matter
think
on
it will-
Wednesday, then your lordship will pass a appropriate order. That will be done, my lord.
Pardon?
Lordship fix the matter on Wednesday, my lord. Otherwise, today is the date fixed for consideration of the interim order, my lord, as per last order.
Yes.
So lordship fix the matter on Wednesday. Lordship has the past order, my lord.
So, what I suggest to Mr. Tawilder is that all the lines in the order
Lordship.
are to be read together.
Lordship.
I read my lord several times. Last 3 lines, my lord,
So,
it
not
is totally
read it in
clear.
isolation of a one line or two line like that. Who passed the order? Who passed the order?
Director.
Yes, Lord.
Whether before passing the order, the director has consulted any council?
No.
Standing council? No.
No, Lordship, it was not there.
Okay, heard Mr. Borgoya, learned counsel for the petitioner, and Mr. Tawilder, learned standing counsel for the respondent authorities. Person to order dated 4/3/2025, Mr. Tawilder has obtained written instruction and placed the same before this court today. Copy of the same be furnished to Mr.
J.I. Borgoya.
Mr. Borgoya, learned counsel for the petition. And SSL is the matter on Wednesday
As a part of.
as parted. On that day, an endeavor will be met to finally hear and dispose of this petition.
If not dispose of matter, then
In the
interim.
meantime, Mr. Tawilder, learned standing counsel, may file his affidavit in opposition if so advised.
If they want to file affidavit, let them file on Monday, my lord, so that a copy to lo. May I take copy, my lord, photocopy of that? Lord asen ki? Mobile lord asen. The DDM. Dekha 9
Order stay vacating item 19.
Not hearing this case, my lord.
May I please your lordship?
Pleadings
Last
completed.
order, Lordships, I filed a petition. Last order may kindly be perused, Lordships.
My lord, pleadings complete, my lord. Record received, my lord.
This
But
was the
instead
last
of
submission.
My lord, that this again came into the step order vacating. Had there been a admission, my lord, your lordship, you have to, your lordship, enter writ petition may be disposed of, my lord.
That's why Lordship may be.
Is met in several times.
Please,
Interim order is
your Lordship may
42.
peruse the last order.
2023, madam. We are not getting.
One by
One.
My lord, your lordship fix the matter Monday. Your lordship dispose of the entire matter.
Last submission, that was the last submission. Your Lordship may be pleased to peruse the last order also.
Yes,
This
my
was
lord.
the
It
submission.
was again come in the order vacation.
Again it will come.
So it is, no, normally your lordship pass in the main writ petition, my
Un-
lord. Let the writ petition be
Unless
either
and
disposed of.
until dispose of.
Because tomorrow is not possible. Well, already we are having
Even myself.
Monday, my lord.
Okay, on Monday then.
My lord. For final disposal. In the writ petition may kindly be passed the order so that registry may not be.
On Tuesday. Hearing day.
Tuesday. No.
Tuesday, hearing day.
Hearing.
Finally.
Final disposal.
Final here Tuesday.
Petitioner?
No, my lord.
Oh, yeah.
I am
Got a
the,
petitioner.
I
Mr.
filed
J.K.
IA.
Wilson, Learned counsel for the petitioner, and also heard Mr. Barbuya, learned counsel for the
Respondent number 8.
respondent number 8. Who are for the other respondent?
I am for the respondent number 7, my lord, and I have also filed an interlocutory application, my lord. Respondent number 7.
Your name, please.
M.A. Hussain.
Learned counsel for the respondent number 7. Respondent number 7. Other respondent?
No, 6 not appeared, my lord. Service is complete, I have seen.
So, it is submitted that pleadings have already been completed, and as such, the matter may be listed for admission hearing on next Monday. And on that day, an endeavor may be made to dispose of the petition.
My lord,
Accordingly, it is provided that resolution is the matter.
Praying for Tuesday, Lordship.
Tuesday, okay.
Let it be on Tuesday, Lordship. Tuesday.
My lord, records is there, may be retained, my lord. Record is there, my lord. May be retained, my lord. As per earlier.
Oblige.
Record shall be retained till then.
Item 20 for admission.
Right to your lordship. Lordship, there was a direction to produce the original select list, lordship. Lordship, I prefer 1 week time, lordship. Although they have sent through in WhatsApp, lordship, but that is not much readable. So lordship may fix after 1 week, lordship. I will produce that original select.
Yes, Mr. Rosit.
My lord, if they are taking time, lord, then there is production of the say original select list. So let them produce, my lord.
Okay. Heard Mr. A. Rosit, learned counsel for the petitioner, and Mr. Sharma, learned standing counsel for the elementary education department. Mr. Sharma submits that he may be granted 1 week time to produce the select list. Dated 27/10/1999.
27.
27, 10,
Care is
1999.
accordingly allowed. List the matter after a week.
On 20, my lord, 20 March.
On 25, lordship.
25.
25.
Okay, 25.
Item 21.
March.
Yeah, please, your lordship. In this case, lordship, instruction was sought for.
Yeah. Who is for the respondent authorities?
Elementary education, lordship.
Mr. R. Mazumdar. Elementary Education Department.
Instruction to আহিছে নেকি? Instruction, my lord, regarding letter dated 7/3/2013 was called for, my lord.
Lordship will fix next week, Lordship. Next week, Lordship.
Have you received the instruction?
No, Lordship. I said, no.
Heard Mr. Vijay Sarkia, learned counsel for the petitioner, and also heard Mr. P.N. Sharma, learned standing counsel for the elementary education department. So Sharma submits that he has not received the instruction. Though a direction was issued by the order dated 28/2/2025 to obtain necessary instruction. And press for listing the matter after a week.
Lordship.
There is allowed, press shall list the matter after a week, reflecting the name of Mr. Sharma as standing counsel for the elementary education department.
My lord, if no instruction is not placed before the court may consider the, my lord, the case on the basis of
In
the
the
matter.
event of failing to produce any instruction on that day, the report will be made to finally hear and dispose of this petition on the basis of materials available in the record.
I am deeply aware.
May I please your lordship to pass this matter some other day?
Okay. On the appear being made by Mr.
Air Bhuya. Air Bhuya.
Here,
Bhuya.
your name,
Vinanda Sangma.
your name,
Mokibul Ali.
Makbul Ali, learned counsel appearing on behalf of Mr. A.R. Bhuya, requested to list the matter after a week. They are allowed to list the matter after a week.
Item 24.
May it please your lordship. Lordship, some time may be given, lordship, as some petitioners could not submit their documents, lordship, as their headmasters were retired, and in charge headmasters are taking their charge recently, lordship. So some time may be given, lordship.
You are for the petitioner.
Yes, lordship.
Your name, please.
S. Patwari.
Ms. S. Patwari, learned counsel for the petitioner. Press for listing the matter after?
After 3 weeks, lordship.
After 3 weeks. After 3 weeks. They are allowed to list the matter after 3 weeks.
Item 25.
So there was a request for VC from the counsel for the petitioner. Then accordingly, link was sent to him, but perhaps he could not connect. So we will adjourn the matter. Billing for none appears for the petitioner on call. How about Mr.
Yes, that's
Yes,
fine.
learned counsel for the respondent number 1 and 2. This one. And Mr. Upadhyay, you are for 3 and 4. 3 and 4 present. And you? Respondent number 5 present. This is a matter after a week.
Yes, ma'am.
Item 26.
May it please your lordship. Lordship, the matter relates to non-finalization of pensionary benefit, lordship. On the last occasion, respondent number 5 was sought for instruction, lordship. But recently, what has happened, lordship? The provisional pension that has been granted to the petitioner has also been stopped, lordship. That is the new problem, lordship. The petitioner is facing, lordship. Lordship may give a direction to release at least the provisional pension.
I have received one instruction.
Yes. Furnish a copy for me.
Yes, I will find it.
So a request is made to the government for waiving the
Excess amount.
excess amount.
Yes, ma'am.
But why her provisional pension is being stopped?
This is not here mentioned, but my lord, the excess amount has been directed to WEF minor. Here, the government is requested to accord
There is
the
no
necessary.
question of no question of stopping her provisional pension.
Regarding that, I have to take instruction, my lord.
Lordship, I am suffering because of this, Lordship.
Since when your
From
provisional
February,
pension is stopped?
from February, from the month of February, Lordship.
February 2025.
Lordship. I was getting the provisional pension, Lordship. At least direction may be issued, Lordship, that part, Lordship.
So in
Let
this
him
regard, my
obtain
lord, I have
instruction,
instruction regarding the provisional pension.
We'll fix a short date.
Lordship.
Yes.
Short date. Let him obtain instruction.
Lordship.
Why it is stopped?
And my lord, this is another instruction here. And therefore, you are requested to prepare due and drawn statement as per the fixation of the pay as shown below and resubmit the pension proposal along with the action taken report in the light of finance department notification so and so for taking further needful action from this end, my lord. And this is one.
Part Mr. Bordolo, learned counsel for the petitioner. And Mr. Sharma, learned standing counsel for the respondent number.
Respondent.
Five.
Mr. Devi for respondent number 3 and 4.
And I am for the respondent number 1.
No, Mr. Sharma, this letter, contents of the letter is incorporated in the letter dated 11/3/2025.
And
Which you have produced today.
This letter is furnished by my friend and then my lord, letter 11/3/2025 has been furnished by me. And that was probably pension.
Person to order dated 4/3/2024, Mr. Sharma has obtained instruction from the respondent authorities and placed the same before the court. Then perusal of the said instruction dated 11/3/2025. Memo number PEN 6/08/2023/137 reveals that the government is requested to accord necessary approval for waiving the excess drawal of amount of rupees 7,74,565 in respect of the present petitioner. But Mr. Bordolo, learned counsel for the petitioner, submits that in the meantime, with effect from the month of February 2025, 25.
Lordship.
The provisional pension being received by the petitioner is stopped by the respondent authorities. At this instance, Mr. Sharma submits that he may be granted some time to obtain necessary instructions. There is
Lordship, next third generation.
so as to enable Mr. Sharma to obtain necessary instructions.
Lordship, I submit what if that copy may be served upon me.
The copy furnished by copy of instruction furnished by Mr. Sharma shall be furnished to the learned counsel for the petitioner. Okay.
Oblige, your Lordship.
So rest of the matters are that can be taken from him.